Yeah.
Just because we had some new folks join us, we are live right now on YouTube, so please be aware of that. We'll be getting started here in just a few minutes. We're going to let our last folks in, and we'll be getting started momentarily. It's great to see you guys.
There we go.
Good morning, everybody.
Morning.
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 Morning, Jerry. How are you?
Good. How are you, Charlie?
Good. Just wanted to let you know, and any of our new directors that are joining, we are live right now on Facebook, or excuse me, YouTube, pardon me. So we're going to get rolling here in just a moment, and we'll call the roll and we'll go from there. But just as one last reminder, we're about to go with our meeting, but we are live on YouTube.
Oh, yes. Sorry. And I'm not on mute.
Well, good morning. It is now 9:02 a.m. and I am calling the meeting to order. All directors will be unmuted for roll call. With our agenda posting, we invited members of the public to view a broadcast of the Board of Directors meeting, which is live at YouTube, www.youtube.com/State Bar of Texas. We also provided instructions on how to speak at today's meeting. Sign-ups were available until 5 p.m. yesterday afternoon. Members of the public will speak after agenda item 4 and will remain in the Zoom waiting room until it is that portion of the agenda. Please note this meeting is being recorded and that recording will be made available to the public. With that, I will call the meeting to order and ask our Executive Director, Mr. Trey Apfel, to call the roll. Mr. Executive Director.
Mr. Augusto.
Present.
Mr. Alexander.
Present.
Mr. Allison.
President.
Mr. Almanzan.
Present.
Mr. Baruch.
Present.
Ms. Bim.
Present.
Ms. Brooker.
Here.
Mr. Cavillo.
Present.
Mr. Carlos Cardenas.
Present.
Mr. Luis Cardenas.
Present.
Mr. Cook. Ms. Cordova.
Present.
Mr. Crane.
Here.
Ms. Davis.
Present.
Mr. Dawson.
Present.
Mr. Docupil.
Present.
Ms. Hernandez Ferrier.
Present.
Ms. Barunda Firth. Mr. Fisher. Mr. Flores.
Here.
Ms. Forbes.
Present.
Mr. Ginn.
Here.
Ms. Goldsberry.
Here.
Mr. Gravely has an excused absence. Mr. Harris.
Here.
Ms. Harrison.
Here.
Judge Hatch.
Here.
Ms. Hoggard. Ms. Humphrey.
Present.
Mr. Hurst.
Here.
Mr. Kolodowski.
Here.
Justice Learman.
Here.
Ms. Cortez Matas.
Present.
Mr. McDougall.
Present.
Ms. Cara Miller.
Here.
Ms. Emily Miller.
Here.
Judge Morales.
Here.
Ms. Mount.
Present.
Ms. Murphy.
Here.
Mr. Naylor.
Here.
Ms. Rispoli.
Here.
Ms. Rowe.
Here.
Mr. Schrammick.
Here.
Ms. Scott. Mr. Sergi. Mr. Sims.
Here.
Mr. Jason Smith.
Here.
Mr. Michael Smith.
Here.
Mr. Todd Smith.
Here.
Mr. Sorrells.
Here.
Ms. St. Ives.
Here.
Mr. Tolchin.
Here.
Mr. Vargas.
Here.
Mr. Vasquez.
Here.
Ms. Welburn.
Here.
Mr. Wester.
Here.
Ms. Pack Wilson.
Present.
Judge Erie.
Here.
Mr. Chair, we have a quorum.
Trey?
Thank you, Trey. I'm sorry, was there Ms. Scott? Yes, ma'am.
Yes, sorry, I'm here. I was on mute.
We got you. We're glad you're here. Thanks, Mary. All right. With that, I'd like to call on Director Rob Crane to unmute and lead us in the invocation for today. Rob, the floor is yours.
Please bow your heads. Dear God, we thank you for safely returning us for service to our fellow lawyers and fellow citizens of the state of Texas. We ask for your wisdom, grace, and compassion to guide our intentions and actions as we move forward in challenging times. We ask you to provide comfort for all those who feel the loss in our judiciary this past week. A loss of not only an historic person and role model, but for many, the personal loss of the convictions and ideals Justice Ruth Bader Ginsburg brought to the administration of justice. We thank you for her service. In all that we do today and every day, please be a reminder to us all that you made each and every person on your earth, that we are all your children, equal in your eyes. Our country that you have blessed so immensely was founded on the idea that all men are created equal. Yet when first put to parchment paper announcing the freedom of this country, our laws did not treat all men or women as equal. Through your guidance, it has been the administration of justice through lawyers and judges over nearly 250 years to make the greatest strides towards attaining that idea. Please help us continue to strive for that idea in all that we do. And in that journey, help us to be mindful that what unites us is far greater than what divides us. As we proceed with our work today, please also fill our hearts with gratitude and good humor. Our work here is often confined by restrictions and limitations, but please help us to appreciate the great honor to find solutions, to be of service to our members, and to promote equality for all your children. We've been witness to our selfless staff working extended hours to rise to recent challenges. We are grateful for their service. And we've been witness to the chair of our board lead with openness and grace. We are grateful for his service. And as a personal request, could you please give longevity to the nickname bestowed upon our chair, a nickname given to him by a member of the bar for his recent exemplary service, that nickname, the Texas Treasurer. We thank you for the opportunities you bring us today, and please lead us in work today, which glorifies you. Amen.
Thank you, Rob, for that wonderful benediction, or invocation. I don't know that I've ever wanted to hit somebody after a prayer before. Thank you very much. I'll ask Director Sherry Goldsberry if she would please lead us in our pledges. Thank you.
Did I really do that on mute? I'm sorry. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee. Texas, one state, under God, one and indivisible.
Thank you, Sherry, for that. We appreciate you being here this morning. We are going to go now to the remarks from the general public. We'd like to welcome any members of the public who have signed up to speak. Members of the public, you will be kept in the Zoom waiting room until it is your turn to speak. I'll address you and give you the floor for that. Please understand you'll be given 3 minutes to speak. In keeping with the traditions that we've done over the last special board meetings, I will stand up at your 1 minute warning, and at that point, I'll ask you to wrap up your thoughts once you've hit your 3 minutes. So I believe our first speaker, we appreciate you being here this morning. We are going to go now to the remarks from the general public. We'd like to welcome any members of the public who have signed up to speak. Members of the public, you will be kept in the Zoom waiting room until it is your turn to speak. I'll address you and give you the floor for that. Please understand you'll be given 3 minutes to speak. In keeping with the traditions that we've done over the last special board meetings. Ms. Parks, if you would turn your YouTube feed off because there's a delay. So that's where the confusion is right now. So if you would turn your YouTube feed off and just go off Zoom, I think that would be helpful for us. Is that okay?
Yes.
Perfect. I heard my own voice and got confused and thought I'd messed something up. So I appreciate you being here today. Ms. Parks, you have the floor. Your 3 minutes starts now. Thank you.
Okay, thank you so much. Good morning. My name is Tanya Parks. I'm the owner of Justice 2, created for oversight of the judicial process due to my experience within the judicial system. I would like to thank you for giving me this opportunity to speak on my behalf, as well as so many others who have lost public trust in the Texas State Bar and the ones that lead it. I am here today as an African-American woman who is a victim of institutionalized and systematic oppression and racism in the justice system, your organization, and your leadership. Jerry Alexander, John Browning, and Jason Barrett, and Judge Sally Montgomery intentionally worked with others to railroad me out of court by misrepresenting the law to get me to dismiss my case, that Judge Montgomery even stated on the record that the defendants were the problem, and she hated that they lied. I have presented material in my packet that I will discuss a few of the reasons why I'm here today. In those materials, you will see how your previous president, Jerry Alexander, and John Browning violated my due process and the ability to have a fair trial in front of an impartial judge. I can show how they used their credentials and titles of advancement within the state bar to secure their protection on grievances consistent injustices in the court of law and use them to intimidate others while also creating alliances to cover up and silence their misconduct. I'm going to read you just a few statements in an email that I sent to Ms. Claire Reynolds and Ms. Sheena Willings in your organization to express my concern about a couple of the promotions with John Browning. In one of the emails, John Browning had just gotten promoted to the Fifth Court of Appeals, and some of the actions that he has done to me, they know about through previous conversations, and they have done nothing to protect my interests. They, in one particular hearing, that I had to give testimony against their misconduct and the lies that they did in court, along with the collusion and the conspiracies and the conflicts of interest that they established. They had 6 bailiffs in a courtroom to basically intimidate me. So while I was giving testimony against them, I would be intimidated and threatened that if I did not stop or did not say something appropriately, then who knows what would happen. And I didn't have anyone there for my protection. I did have a lawyer, but that was it. I was the only witness. And in that, we tried to even recuse the judge beforehand so that I could have a trial in front, but they would not allow that. And they actually brought in a judge, Emily Miskell, to hear a recusal hearing where John Browning and John Browning were Miskell and John Browning have previous working relationship and working ties. So, and John Browning was currently at that particular time running for the Fifth Court of Appeals as well. And so in this email, I also tell her about all this. And I said, this
Ms.
is
Parks, please finish your thought.
And judicial supremacy and inequality. They look at me as a Black woman and they don't care. And so then Ms. Reynolds replies back and she says, I can certainly understand your frustration and I absolutely hear you and understand that what you are saying in regards to systematic oppression, systematic and institutionalized racism in this country. I believe you and I do not at all think that you are a threat or a threat to anyone. I'm sorry. And so basically what I'm saying, you guys, I really do believe that you guys need to bring diversity into your leadership because due to the inconsistencies and the discipline actions against African-American lawyers who are not a part of your leadership, I can show how it is difficult for victims like myself to hire a lawyer against your establishment and judges with political influences. They are fearful of the same
Ms.
retaliation.
Parks, I don't mean to cut you off, and Ms. Parks, I'm so sorry, but
I'm so sorry.
okay. Thank you, ma'am, for your comments and for your time today. Thank you very much.
Bye-bye.
Our next speaker is Derek Smith. I'm so sorry, Mr. Rich Robbins. Mr. Robbins, are you with us?
Can you hear me? Can you hear me, Joe?
Yes, sir. The floor is yours, and since you're calling in on the phone, I'll give you a verbal warning at the 1-minute mark. You've called in before, so you know how that works. Mr. Robbins, the floor is yours, sir. Your time starts now.
Thank you, Texas Treasure. Okay, good morning, ladies and gentlemen. Thank you all for your service to the bar and to Texas. I appreciated the commentary just now by Ms. Tanya with regards to how we don't have a particularly fair grievance system, at least in the perception of ethnic minorities, and as a result, it is harder for some people to get attorneys to champion their cases and causes. If grievance reform could happen, then the perception of unfairness could be greatly diminished. There are various grievance reform proposals that numerous Texas attorneys have contributed to the compilation of. They're available at texasbarsunset.com. You're always welcome to check that out, morning, noon, and night. Now, according to agenda item number 16, the referendum with regards to certain items is coming up soon, potentially anyway, to the exclusion of grievance reform. Why not consolidate referendums to save the bar money and reduce voter fatigue and thereby enable grievance reform to get voted on in the upcoming referendum? It's a problem that is particularly affecting minorities, as Ms. Parks was just mentioning, and it's something that's well worth your addressing, please. I'd also like to speak to agenda item 15, and that has to do with the elections of presidents, for example. Currently, to be a petition candidate, one needs around 5,000 signatures. Apparently, only Steve Fisher and Joe Longley have ever achieved that. It's also interesting that since 2006, when Texas Bar Sunset, which I maintain, started compiling data, we've only seen the voter petition.
Mr. Robbins, you have 1 minute, sir.
Thank you, sir. We've only seen the voter participation rate reach or exceed 30% 3 different times since 2006. 2 of those times were when there was a runoff candidate involved, Joe Longley or Steve Fisher. Why not make it so that there are only 1,000 signatures required in the future to be a petition candidate? Variety boosts interest. The voter participation data is also at texasbarsunset.com, by the way. And finally, with regards to the referenda agenda item of merging, or I should say, granting reciprocity to federal entities and courts in the State Bar of Texas judicial system and disciplinary program, why not maintain the independence? Otherwise, it's going to be harder for Texan entrepreneurs to inspire their attorneys, their long-trusted attorneys, to represent them in federal courts. As you know, federal courts and federal agencies, the leaders are not...
Mr. Robbins, please finish your thought, sir.
Okay. The leaders are not democratically elected, and as a result, we don't necessarily get the best justice in such entities. Why not protect Texans from losing their attorneys in the event of needing to go into federal courts by maintaining the independence of Texas discipline from federal court discipline and federal agency discipline? Thank you very much.
Thank you, Mr. Robbins, for your time and for your comments this morning. Mr. Steve Bolden, are you on our call, sir? Steve, if you're there and you're muted, we can't hear you, so you might unmute yourself. There you are, Mr. Bolden. How are you? Can you hear us? Still on mute, sir. I see that you're on mute, Mr. Bolden. There's a button that says connect to audio. Make sure you selected that. There you are. Can you hear us?
Yes.
Yes, sir. The floor is yours. You've got 3 minutes, sir.
Oh, great. Well, good morning, everyone. I'm here to talk about electronic signatures for petition candidates, but in particular, what I would like to say is that we need one state bar. One state bar that's comprised of over 105,000 lawyers that come from small firms, large firms, criminal lawyers, defense lawyers, plaintiffs lawyers, lawyers from East Texas, West Texas, Black, white, brown. All of these lawyers have a voice and need to be heard. And lawyers want to be heard, and they also want to be respected. And how we maintain one state bar of Texas is allowing these voices to be heard. And how they can be heard is removing impediments to these voices. And how we can do that right now, and it's a moment of reform, is to allow for electronic signatures for petition candidates. In particular, right now, we're under a pandemic, and to force a petition candidate to get wet signatures today in this time and age is not good. Not only that, it's also the number of signatures that is currently required. Right now, you have to have 5% of regular members sign that petition. There's 105,000 lawyers plus. If we were just talking about African Americans, there's only 5,700 African Americans. And so in this day and age, if there was an issue that was just unique to African Americans and they wanted to have a voice, they would have to get 5,500 signatures. That's a daunting task.
You have 1 minute.
Thank you. And so today, it's not just lawyers of color who want to be heard. There are lawyers in East Texas. There are lawyers in large firms. There are lawyers who are Democrats, Republicans, all these kinds of voices that want to be heard. And today, what I urge this board to do in a spirit of reform, because we are one state bar of Texas and we're a great bar, is to allow for electronic signatures, especially in light of the pandemic we have right now. But additionally, the requirement for 5% of regular members, when the Texas Young Lawyers only requires 500 people, and we're requiring this large number, I think it's not one where a bar that is mandatory and a united bar, it doesn't work. And so I urge for you to vote in favor of electronic signatures and also to reduce the number of the 5% requirement. Thank you very much.
Thank you, Mr. Bolden, for your time and for your comments today. I don't believe we have any other members of the public here. Derek Smith, are you with us? If you are, please unmute yourself. I don't see you on the screen. If you are, please get in touch with us at Amy Starnes' email, the same email you used to sign up, and we'll get you in. At this point, though, I believe we've heard from every member of the public who signed up and was present to speak. The public comment period is now closed. During the remainder of the meeting, if there are board members or staff who wish to speak at any time, please use that raise your hand feature on Zoom. You can do that at the very bottom of your screen. Director Sergi, I saw your hand raised earlier. I was assuming you were just letting us know you are here. We do have you on the roll. Thank you for being here, sir. So at this point, we're going to move to item number 6. President Larry McDougall has some resolutions to present. Mr. McDougall, the floor is yours.
Thank you, Mr. Chair. I believe on the list I have, the first is Attorney Ralph Gonzalez. I'd like to say a little bit about Ralph in this resolution. The resolution itself is online, but let me tell you a little bit about Ralph. I first met Ralph when he became a baby prosecutor in the Fort Bend County District Attorney's Office. And to my belief and knowledge, he was our very first Hispanic prosecutor in Fort Bend County. Ralph has always been a go-getter. After serving with the prosecutor's office for 10 years, he left and started his own practice as a criminal defense. And this is where Ralph really stood out. Ralph immediately opened his door to the other lawyers. With the younger lawyers, he was giving advice. He was letting lawyers sit with him. He mentored young lawyers. And Ralph continues doing this to this day. In fact, one of the ones that he's probably mentored the most is his law partner, who's his daughter, Lisa, who also office with him. It's people like Ralph that we believe gives the criminal defense bar a good name. He works hard to work with other lawyers. He basically, and give you a little background on Ralph. Ralph is a son of Mexican immigrants. He was the first in his family not only to graduate law school, but the first to graduate high school. He served in the military, and from the military, he worked his way through college and law school. Ralph didn't have it easy, but he made a success of it. Ralph is one of the ones that basically pulled up his bootstraps and went to work and made a success. And of that, I am proud to honor Ralph Gonzalez because of everything he has given back to the legal community. The mentorship he's given our young lawyers has been outstanding. He served as president of the Criminal Defense Bar in Fort Bend County. And to that, Ralph, I would like to present you with this resolution. Thank you very much, Ralph Gonzalez.
Congratulations to Mr. Gonzalez and to his family. Our next resolution is, let's see. Mr. Gonzalez, are you on the call?
I am.
Mr. Gonzalez, if you would like a few minutes to speak, normally we do this in person. So I'm sorry we're doing this virtually today, but if you'd like a few minutes to speak, we'll give you the floor for 3 minutes, sir. The floor is yours.
Thank you very much. I am humbled by even being considered for this award. I had another response planned, but my daughter said, no, not that one. When I go back and see where I came from, I know my parents would be proud. When asked, are you the first one to graduate from college? My response is no, I'm the first one to graduate from elementary school. And that normally gets the conversation started. The neighborhood I was raised in may be tough and not willing to back down from a fight. Today, I carry that attitude in the practice of law and try to instill that attitude in the new lawyers I meet. We live in the greatest country on earth, and we are involved in one of the greatest professions on earth. But I could not have got here without my family. My wife, Gloria, who has tolerated me for many years. My daughter, Lisa Marie Gonzalez Salceda, the lawyer scientist in my office, who practices with me. My son-in-law, Alberto Salceda, who works for the Public Defender's Office in Fort Bend County. And for my two granddaughters, age 7 and 3, Victoria and Emilia, who at their tender age now argue like lawyers. I thank God for all that God has given me, and I say, God bless America. Thank you.
Thank you, sir. Congratulations on your resolution. Certainly well deserved. Mr. McDougall, you have another resolution to pass. The floor is yours, sir.
Thank you. Next, we want to honor Richard Dick Tate. Mr. Tate has been an outstanding warrior for lawyers in Texas. Mr. Tate served for basically 21 years as the chair of the Texas Access to Justice Foundation. He has given so much of his time for the poor and providing legal services for them. A fact that a lot of people don't know is he's now surrendered part of his law office to Gulf Coast Legal Aid. So when you drive by his office in Richmond, Texas, you see that there also. Mr. Tate has also provided years of litigation to cement the constitutional validity of the interest on the Texas Lawyers Trust accounts, our OLTA accounts, which has provided millions of dollars in the basic legal services for the poor. Mr. Tate's also served in many other factions. He's basically known as a go-to lawyer in Fort Bend County. He is probably one of the most revered lawyers in Fort Bend County. And with that, Mr. Tate, for all your years of service and everything you've done for the lawyers of this state, I would like to present you with this resolution from the State Bar of Texas.
Congratulations, Mr. Tate. Mr. Tate, are you on our call? If you are, please unmute yourself. We're showing that you are. There you are, Mr. Tate. If you would just unmute yourself, there you go. If you'd like to say a few words, sir, the floor is yours.
Thank you. Thank you, President McDougall, Chairman Ginn, and members of the board. It's indeed an honor to join you this morning and to receive this recognition through the form of the resolution. I received the resolution framed in my office night before last, and it's truly very nice, and I appreciate it very much. Serving as the board chair of the Access to Justice Foundation has been the singular most rewarding experience that I've had in my 41 years of law practice. The things that I've seen done in Texas by just incredible lawyers who have chosen to devote their lives to essentially to poverty law it has just brought tears to my eyes over and over again over those 41 years. We have in Texas what I've always called the gold standard of provision of legal services to those who deserve them but can't afford them. And more importantly, thanks to Justice Lehrman, Justice Heck, Justice Guzman, and now Justice Busby, and the entire Supreme Court, we are known nationwide as basically, as I said, the gold standard. And it's because our Supreme Court has made it such a priority, and they've made it, they've just made everything easy for us as those who attempt to deliver the services on a daily and yearly basis. Thank you for the recognition of this resolution. I thank my family, as Ralph did. Ralph and I are old friends, and this is sort of Fort Bend County Day, I suppose. And thank you, Chairman McDougall. And I'd like to thank my family, my wife, Kathy, and my son, Alex, who have supported me in this endeavor for the total of 27 years that I've been on the foundation board. I stepped down formally yesterday, and Justice Deborah Hankinson will be taking my place, and there is no doubt that Justice Hankinson and this Supreme Court will take the Texas program to greater heights. And let me just say, finally, that we've had a great court. We've had great court support. We've had great lawyers practicing in the field. But we've also had the unique support of the State Bar of Texas every step of the way. The State Bar puts together in April of every year. It's just a banner team of public spirited lawyers to go to Washington and meet with the entire Texas congressional delegation. And assuming the pandemic eases before next spring, Chairman McDougal will lead that effort this year. I mean, President McDougal and Chairman Ginn will lead that effort this year. And we thank the State Bar for its unceasing support, and we look forward to better things ahead in our Access to Justice program in Texas. As I said, we're the gold standard. We all intend to keep it that way. And we thank all of you for your support and everything you've done to put us in that position. Thank you again.
Congratulations, Mr. Tate, to you and your family. I know this is a well-deserved honor. Congratulations. Mr. McDougal, you have another resolution, I believe. The floor is yours.
Yes, I do, Mr. Chair. Next, we'd like to honor the Honorable Rodney O'Neill Williams, Judge of the 268th District Court.
Thank
Give you
you.
a little background on Judge Williams. Judge Williams' youth started in the 3rd Ward of Houston. He worked after graduating high school, he joined the U.S. Air Force, where he became a law enforcement officer in the Air Force, which subsequently led to a position with the Fort Worth Police Department. Mr. Williams, or Judge Williams, worked his way through college and law school, serving the public. Upon graduating law school, he spent 16 years as an attorney in private practice and then did 2 years as a senior trial lawyer in the Office of the Public Defender. He's the first African-American elected judge of the 268th District Court here in Fort Bend County. He was elected in 2018. As judge, he has shown his passion for the law and his passion for fairness. He has been a proponent of bail reform, reviewing the bail in each and every case that came before him and modifying them where he deemed appropriate. He provides hearings, he provides access to judges. And the last nominee we had, he will tell you that when he has a question, he asks himself, what would Judge Sandy Bilstein do? He is committed to the civil rights and equal justice for all, and he is extremely dedicated to the legal profession. And as such, I would like the State Bar to honor Judge O'Neill Williams with this resolution.
Congratulations, Your Honor, and for this resolution. Are you with us today, sir?
Yes, I am.
The floor is yours.
Thank you. Thank you. I don't think that I'll need 3 minutes, but I'll try to stretch my time a little bit. Thank you to the president. Thank you to the board. And thank you all very much for the honor. I think it's fair for me to say that I would not be where I am today were it not for the guidance of Judge Bilstein, who formerly sat in the County Court at Law Number 4. But it is also fair to say that I wouldn't be where I am without the support of the man who is now our president. He began urging me to run for office in 2016, and I said no. Then he wanted me to run for office for 2018, and I said no. Until finally it sunk in that maybe this was the best course. You see, I started in police work as an idealistic young kid thinking that I could save the world. After becoming a police officer, I realized that one officer can't change much. So I decided I'd be an attorney, and I spent midnight shifts studying to get a degree, to become a lawyer. And I worked my way into law school at Tulane University. after becoming a lawyer, a defense attorney, I worked criminal defense, or what I call you'll never get rich law. And I worked my way through the process, learning by watching your president, our president, Larry McDougall. And I know from being a criminal defense lawyer that the system is indeed broken. The system didn't break at the time of the 2018 election. The system was broke before that. And so what I've endeavored to do is to try to make changes in this one court to fix what is broken and what was wrong. We've tried to pay for criminal defense attorneys who are appointed to represent the indigent. We've tried to up the pay so that we can get the more experienced and the top flight attorneys working in Fort Bend County to take the cases of the indigent. Nobody got into this business to be poor except me. And no, that's a joke. I hope that is that's viewed as a joke. But we all know that criminal defense attorneys are not the highest paid. We also know that those working to serve the indigent are not the highest paid. So we've endeavored to increase the pay for those attorneys who practice before my court, and it's working. As I said, we tried to draw in the best attorneys and make sure that those attorneys who come in to represent these folks are not overworked because they have to work on such high volume. As I said, I think it's working. What we also are endeavoring to do now is to take a look back. As I said, the system did not break on the day that Democrats took over a few courtrooms in Fort Bend County. The system was broke before then. So we are endeavoring to take a look back and to look at sentencing that happened in the times before. And when we get that done, I think that we'll have taken a big step towards fixing what may have been wrong before. But then we have to make sure that we never go back to that. And I thank you all for the honor and allowing me to be here this morning. Thank you very much.
Thank you, Your Honor and Judge, and congratulations to you and your family on this award. I'm sure it's well deserved. Mr. McDougall, you have one more resolution, I understand.
Thank you, Mr. Chair. And this is the one I saved for last. You've already heard mention of Judge Sandy Bilstein. Judge Sandy Bilstein is one of those judges that, in my view, and I believe that of Judge Williams and back Judge Richard Tate and also Ralph Gonzalez and most of the lawyers in Fort Bend County and surrounding counties basically obtained the status of a legend. He is what we believe every judge strive to be. He was one of the most fair, knowledgeable, and open judges that you would have ever met. Today, many judges hide in their chambers behind locked doors because of security threats. Judge Bilstein wouldn't do that. He kept the doors to his chambers unlocked. He kept a pot of coffee on all the time, and he had a spot for every lawyer that wanted to come talk to him. As long as your case wasn't pending in his court, he would be more than willing to talk to any lawyer. It was frequent to find criminal defense lawyers, prosecutors, plaintiffs' lawyers, insurance defense lawyers, probate lawyers, even family lawyers in his court seeking his wisdom and advice. And he was never shy and never denied taking the time to sit down with a lawyer and discuss it with them. He was there for every lawyer. He made his courtroom available to any lawyer group anytime they wanted it. He maintained that open door policy even before becoming a judge. His door to his office in private practice was always there. Sandy is from Tyler, Texas originally. He grew up, was a Marine in Vietnam in the 1960s. He was a Houston police officer. That's how he worked his way through college and law school, graduating from South Texas College of Law. He was a homicide lieutenant when he retired. And you would think by looking at his background that he would have been one of those ones that was hard as nails. But actually, he turned out to be one of the most compassionate, caring people that anybody would ever find. We have the wheel is which judges use now to give court appointments. But every week or every docket, be it the Tuesday criminal docket or the Friday arraignment docket, Judge Bilstein would always pull cases off and he would hold them off the wheel. And the reason he did this is young lawyers graduating from law school or leaving firms or young prosecutors leaving the DA's office knew that they could come to Judge Bilstein's court and he would have a court appointment for them. He was big in helping young lawyers new to the practice of criminal law in getting appointments and starting their careers. This is something that he did from the beginning of his time as judge until his death in 2017. This man was not only a legend, but he was a model for what I believe every judge should strive to be. Today, I would like to ask the State Bar to possibly honor Judge Sandy Bilstein for his service both to the nation, his community, his commitment to the fair and just application of law, his tireless community service, and his total dedication to the legal profession. Thank you.
Thank you. And I believe that we have Judge Bilstein's son with us today. Is that right? Are you with us, sir?
Yes, sir.
All right. The floor is yours for 3 minutes. Congratulations to you and your family.
Thank you. Oh boy, I was doing all right till O'Neill said the things that he said, and Mr. McDougall said it's an honor and privilege basically to be here. And I thank the board for honoring my dad, Judge R.H. Sandy Bilstein. It's kind of a bittersweet day today because today's a 5-year anniversary of a restaurant that my dad and I opened. So, Dad used to have a saying that it sticks with me to this day and sticks with a lot of people. He used to say, I'm not Republican, I'm not Democrat, I'm American. And as you can hear, or as you've heard from a lot of the things that Mr. McDougall said and Judge O'Neill said, Dad was, he had the open door policy, and he always cared about everybody else and wanted to teach and make sure everybody learned everything that they possibly could. He's my role model. He's my mentor. And even in death, he's still my hero. I'd just like to thank y'all very much for this. It's very deserving, and thank y'all.
Thank you, sir, for being with us and for your comments, and congratulations to you and your family for your father's award. I'm sure it was well deserved. With that concludes our presentation of the resolutions, and we do have a ceremonial swearing in to do that I'm going to ask both Dr. Ferrier and Justice Learman to unmute themselves. She is a public member, Dr. Ferrier. She was appointed by the Supreme Court for a 3-year term, and she was sworn in before the July 27th, 2020 special meeting, but we wanted to make sure that we accomplished that today. Justice Learman, the floor is yours, ma'am.
Thank you so much, Mr. Chair. It is my extreme honor to be able to welcome our newest public member, Dr. Maria Hernandez Ferrier. Dr. Ferrier, could you please raise your right hand?
Yes.
I, Dr. Maria Hernandez Ferrier.
Dr. Maria Hernandez Ferrier.
Do solemnly swear.
Do solemnly swear.
That I will faithfully execute.
That I will faithfully execute.
The duties of the Office of Board of Directors.
The duties of the Office of Board of Directors.
Of the State Bar of Texas.
of the State Bar of Texas,
and will to the best of my ability
and will to the best of my ability
preserve, protect, and defend
preserve, protect, and defend
the Constitution
the Constitution
and the laws of the United States
and the laws of the United States
and of this state of Texas.
and of this state of Texas.
So help me God.
So help me God.
Thank you so much, Dr. Farrier. We, the State Bar of Texas and the Supreme Court of Texas is thrilled, and I say that from the bottom of my heart, thrilled to have you join us in this very important endeavor. Thank you for your commitment and your willingness to serve.
Thank you, Justice Lehrman.
Thank you.
Thank you.
Thank you, Dr. Farrier, for joining us. We're excited to have you, and Justice Lehrman. We are going to take item number 24 out of order for Justice Lehrman to give us her report, and then we will proceed to item number 19 for Director Goldsberry's report, and then we'll get back on schedule. Justice Lehrman, the floor is yours for your report, ma'am.
Thank you, Chair again. I want to start, as always, by thanking the wonderful staff of the State Bar of Texas, the wonderful volunteers who serve so diligently, and our leaders, certainly Chair Ginn and President McDougall. Thank you all. It's such a tough time in our society with so many things going on with the pandemic, with all of these amazing environmental issues that we're having to deal with in our state and across the nation in terms of hurricanes and fires and those kinds of things. The social unrest that we're experiencing right now, and that's only a small portion of the things that are just so challenging at this time. And nobody is more committed to dealing with those issues in a way that's going to help all of us than members of this board, the State Bar of Texas, and members of the legal profession generally. So I want to, on behalf of the court, thank you all so much for your commitment, for your dedication, and for your hard work during these very challenging times. So we have quite a bit to report because things are so crazy right now. Generally, just to let you all know, the court is not meeting in person. We have not met in person since March. Everything is done by Zoom, including our conferences and our oral argument. We have 18 new law clerks who started this week, and they are all participating remotely also. That's a bit challenging because, as you all may know, each chambers has 2 new staff law clerks that comes in every year. Last year, when the pandemic hit and we were all quarantined, we knew each other by March very, very well. We get to know each other very, very, very well. The intensity of the work is huge. And so for us to work at home wasn't really that unusual or hard because we were at that point in time getting down to getting all of our opinions down to paper, to studying, to going back and forth over each other. Over each other's work. It's the most intense time of the court. Now, however, with these new clerks coming in, it is challenging because getting to know somebody by Zoom just is not the same as getting to know somebody in person. So we're trying to deal with this the best we can, as I know all of you are as well. As I said, we started oral arguments by Zoom this past month. We will continue. We're having some emergency issues that are being presented because of the pandemic. We'll have oral argument again next week. And we have decided as a court that we'll continue those Zoom oral arguments at least through November. We're constantly working with the health officials. As you all know, we have, I think to date, it's 2,300 new cases per day and over 100 deaths in our state alone. So we have to be mindful of that tragic effect on members of our society. As many of you know, Justice Green retired on August 31st. He was our senior judge for the past 7 years and it served as an associate justice for years before that. and we are certainly going to miss him. We have not really had any word on a new appointment to fill this vacancy, but of course, the governor, as all of us, are really working overtime, and so it's understandable that that has not been dealt with yet. I'm very sad to report that Justice Eugene Cook recently passed. Perhaps his most notable contribution to the court was that he was the author of the Texas Lawyers Creed, and of course, we will all be very mournful over his loss. And I would also like for us to reflect a bit, as was stated earlier, about the profound contributions that Justice Ruth Bader Ginsburg had on the jurisprudence of our wonderful country. She did so much for the legal system and for the jurisprudence of the country, of the nation. And for that, we are all mournful, certainly on this very sad day that is focusing on her legacy, on her work, and the tragedy of our country losing such a wonderful, wonderful scholar and contributor to us all. With regard to COVID emergency orders, let me just tell you about the few of the most recent. With regard to bar dues, we extend the state bars due deadline from August 31st until October 31st in the hopes of helping lawyers be able to deal with some of the stuff that's difficult economically. The statutes of limitation deadlines that were to fall between March 13th and September 1st, that was extended to September 15th. With regard to evictions, we have extended the pleading requirements in eviction cases until December 15th. As you all know, an eviction case cannot go forward because it's barred by federal law under the CARES Act or the CDC, which is broader in what it has barred. However, frequently tenants don't know about this law and the landlords do. So we have imposed a pleading requirement on the landlords to state that they don't know of any reason why the eviction can't go forward under the CARES Act or under the CDC broader order. We've also directed the JPs to provide information about the CDC order to tenants in the citation, and we've made clear that they are allowed to question whether the tenant knows about these federal requirements and the CDC order. We are also working on a program on eviction diversions to help landlords and tenants through federal monies. This should help both sides of the equation in terms of helping the tenants pay the rent and the landlords receive the rent. The governor, we've been working with the governor on this. He should make an announcement on this very shortly, hopefully this afternoon. With regard to the bar exam, we've had to shift gears, as you all know that. Unfortunately, weeks before the July bar exam, there was a huge surge in COVID cases. Exam sites were canceling, etc. And so we postponed that exam. We then offered the examinees two options, an in-person exam, which did occur on September 9th, and an online exam, which will occur in October. For the in-person exam, the Hilton Hotels chain was wonderful in working with the Board of Law Examiners. Each examinee was assigned an individual hotel room to take their exam in. It worked out well. One of my clerks took the exam and said it was really, really better, he thought, than it would have been taking it the way that we all took it, because they all had individual rooms. It was completely private, of course, with their own restroom there. 2-day exam. They could spend the night there at no cost to them. There were proctors, and thankfully we had a lot of proctors. The doors, of course, had to be kept open in the hotel rooms, and proctors walked in and out to make sure that nobody was cheating. It seems to have worked very, very well for everyone. The online bar exam, as I said, is moving forward for October. There's about 30,000 examinees who signed up nationwide. I'm not sure what those numbers here are here in Texas, but I can get those numbers. With regard to general emergency order, we've extended that general emergency order that allows individual judges to suspend and modify procedures and requires those judges to take protective action to make sure that people are kept as safe as possible. We've also addressed the path forward for jury trials. Since March, we've had 18 test jury trials. Of the jury trials that OCA has approved, about half were canceled, however, for various reasons. Although we've had quite a few problems, we are marching forward. You might have seen that OCA issued a report at the end of August recommending that path forward, and I would commend that report to you. The court adopted those OCA recommendations. So effective October 1st, in-person jury trials. Justice courts and municipal courts are prohibited from conducting in-person jury trials until December 1st. The 1,500 cases that are usually tried in justice courts and county courts dealing with these must be tried virtually. Like I said, they cannot be in person. So we'll see how that works. With regard to district and county courts, they may move that forward with in-person proceedings, but only if they satisfy a list of requirements, which include their local administrative judge must have submitted a plan to OCA that's been approved. Their local administrative judge and regional presiding judge must approve the trials. That part will no longer go through OCA because it was such a burden on OCA and David Slayton, who's done a miraculous job during this very stressful period of time. The local administrative judge must consult with local health authorities within 5 days of the trial to make sure that the conditions are safe to proceed for everybody who's involved in the proceeding. And the court must consider any objections to proceedings on the record and must establish protocols for ensuring that no participants have recently had or been exposed to COVID. With regard to virtual jury trials under the court's order, they are permitted in all courts, and OCA will issue detailed guidance on how for those to be conducted. The order does specify that for criminal cases where confinement in jail or prison is a potential punishment, consent must be obtained from both the defendant and the prosecutor. But for other cases, the court must consider objections to the proceedings on the record, but consent is not required. And the reason that we did not require consent is because it would virtually have done away with jury trials if there was a party who wanted to maintain the status quo and they simply could have refused to consent. So we have not required that. With regard to the rules amendments, back in June, we gave final approval to the rules requiring citation by publication on the OCA website. In response to Senate Bill 891, we approved amendments to Rule 106 to clarify that service of a citation by social media and other technologies are permissive forms of substituted service, provided that the evidence shows that they're reasonably calculated to give notice. With regard to expedited actions, we've amended Rule 169 and some of the discovery rules to address expedited actions. The changes can be grouped into several categories. The first, we increased the threshold from 100,000 to 250,000, plus changed what's included in those amounts to make the expedited actions process and level 1 discovery applicable to those cases over 250. The second main change is that we increased the number of oral deposition hours in level 1 from 6 to 10 hours to 20 hours based upon feedback that we had received. We did not make any changes to the paper discovery limits in level 1 because of the third main change, which requires mandated disclosure in lieu of the current request for disclosure process. There are initial disclosures specific to divorce and custody that we've changed. So I encourage you to take a look at those and provide feedback because we're still in the comment period. In divorce cases, the proposed rules call for initial disclosure of documents pertaining to real estate, retirement plans, and insurance plans, and the most recent account statements of the parties. In custody, the proposed rules call for initial disclosure of medical or health insurance policies that would be available for the child or spouse, income tax returns for the previous 2 years, and the 2 most recent payroll check stubs. These will take effect January 1st, but we are accepting public comment until December 1st. With regard to the protective order registry, we are delaying operational date on that to, let's see. The registry was supposed to be established June 1st and operational September 1st, but because of the challenges due to the pandemic and the ransomware attack, the Judicial Council extended the June 1st deadline to September 1st, and the court has moved the September 1st operational deadline to October 15th. With regard to the racial unjust that we are dealing with in our society today, as Robert Crane so eloquently stated in his beautiful invocation earlier this morning, our United States Constitution did not treat everyone equally under the law. This has huge ramifications that affect us all today. We must examine ways in which the effects are real and can be dealt with in a way that's proper. The court is committed to address these issues with diligence and care. And with regard to access to justice, this is a huge priority for the court and has been for many years. The wonderful Justice Deborah Hankinson really brought this to the court's attention and made it a priority many, many years ago. I want to, on behalf of the court, thank Dick Tate for his tireless efforts to help those in need with regard to this issue. As Martin Luther King so eloquently said, if justice is denied to one person, it's denied to all of us. Justice Deborah Hankinson has large shoes to fill, but I can think of no one who is more up to the task than Justice Hankinson. She's committed, she's passionate, and I said she is the one who was largely behind the beginning of this movement many, many years ago, and the entire court is indebted to her for that commitment and that service. So again, thank you all to everyone. We are dealing with the challenge of a lifetime, and the court is so grateful for all that every one of you are doing, staff, volunteers, leadership, to get us through this very, very difficult year. Thank you so much.
Thank you, Justice Lehrman, for the report and the updates and for your leadership and for the Supreme Court's leadership during this time. We appreciate you very much. Thank you for your service. Director Goldsberry, are you on our call? I know we had to get you on a phone call. Are you with us?
I am. I'm on the phone. Thank you so much.
You bet. The floor is yours, Sherry.
All right. Thank you. I want to thank everyone that participated in our retreat this year. Our consultant, Elizabeth Derrico, is going through all of that information that we were providing to her over that week. And we should have a plan drafted and ready for the board to look at in January. Thank you.
Thank you, Sherry, and for your team, and we're looking forward to getting that report in January. So with that, we'll move to item number 8, report from the chair of the board. You've already been introduced to Dr. Maria Hernandez-Ferrier. I wanted to tell you a few things about her. She is the founding president and president emeritus of Texas A&M University, San Antonio. She served as the Director General of Mexico Relations for the Texas A&M University System. Before her career with A&M, she held a number of national education appointments. In 1990, President George H.W. Bush appointed her as the Department of Education's Director of Bilingual Education, and in 1992 appointed her to the Commission of Nation and Community Service. In 2002, President George W. Bush appointed Dr. Ferrier as Assistant Deputy Secretary for the Office of English Language Acquisition. She is the founder of the San Antonio chapter of City Year, the national service organization that became the model for AmeriCorps. Dr. Ferrier has been the recipient of numerous awards and honors. She holds a Bachelor of Arts in Speech and a Master's of Education in Guidance and Counseling from Our Lady of the Lake University. Her doctorate is in Educational Administration from Texas A&M University, College Station. Once again, Dr. Ferrier, welcome to the board. We are grateful you're here. We're excited to have you, and we look forward to your leadership with us. So we have a couple of things to discuss in my report. I want to try to be as efficient as possible. I appreciate your time. The first thing that I want to talk to you about is director outreach. Our board, one of our responsibilities is showing Texas lawyers and illustrating to Texas lawyers the benefits of being a part of our state bar, how to maximize their state bar membership. We're going to continue that effort this year, but because of COVID-19, stop me if you've heard this before, but things are different. Normally, we have a map that is put up on the screen, and when our directors will give a talk or show benefit to the lawyers about what we're doing, we will highlight that section to show we have reached our district. I'm not going to do that this year. I know it's difficult to attend in-person CLEs. I know some are popping up, but I understand that's difficult. We are not going to use the map this year. It is my hope that we go back to doing it next year. However, you can do this virtually, right? We are going to send fall messages and a spring message to members of your districts with updates on state bar programs and services. The communication staff will be in touch with instructions for these meetings after the September and January board meetings. The communication materials that I'm talking about are available in the 2021 Communications Workroom in Board Effect. You've heard me say this before, but Directors, Board Effect is your playbook. Please get familiar with it and use it. Also in the board portal are 2 PowerPoint presentations that you can give to local and specialty bars and organizations in your district. One is 30 benefits in 30 minutes. That's accredited for the half hour of MCLE credit, which includes that half hour of the ethics. And the second one is Maximize Your State Bar Membership, which is accredited for 1 hour of MCLE, including 0.75 ethics hour. Those ethics hours are always tough to get for a lot of us. This is a great opportunity to show our districts, to show our lawyers the great services that the bar is doing. Understand that if you don't have contact information for your local bars, we have provided to you in your materials through board portal a local bar roster. We've provided a variety of handouts that can be shared when you present at these local bars, whether that's in present or virtual. But it's important that when you do this, when you set up your talks, that you let the communications team know in advance so they make sure they have all the materials that you need in order to give that effective presentation. This is a great opportunity to show Texas lawyers that there are benefits. Let's take it. If we go to the annual reports, also available on Board Effect, there's copies of the volunteer and staff guide and the new annual report of the State Bar and the Commission for Lawyer Discipline. The State Bar annual report focuses on COVID-19 relief efforts and the expansion of our member benefits program. Please take some time after the meeting, if you haven't already done that, to read through these reports. You should have gotten them in the mail. I did earlier this week. There's great work being done by Texas lawyers. I would really encourage you to read it. And then finally, Board Effect. Please stay active on Board Effect. It is imperative that because we are doing all this virtually, this is our workroom. These are our stations. Please stay active. This is used for a lot of different things. board and committee meeting notifications, schedulings, meeting books to access the materials for the board meetings, surveys and polls. We're going to use Board Effect here in just a few minutes in our election for the State Judicial Conduct Commission. If you're not logged into Board Effect right now, go ahead and get logged in on that second screen so you're familiar with it, but understand it's important. I cannot stress to you enough how important Board Effect is for this year. It's our playbook. If you've got a problem with your login or you can't locate an item, you're always free to reach out to Chelsea and Jennifer. Do not call the Board Effect help desk, all right? They are just going to tell you to call Jennifer and Chelsea. Jennifer and Chelsea are great at Board Effect. They can help you. They help me daily. If I haven't said it enough, our staff here at the State Bar is incredible. Use them. They're great, especially with Board Effect. The main reason that we use Board Effect is it's a one-stop shop for information. You've got resource libraries, you've got public comments, you've got just about anything that you could need as a director on this board is on that Board Effect. It's a one-stop place. So understand that, and understand that we're using Board Effect from State Bar members and members of the public as a gathering station for their emails, for their letters, for their comments. We are still getting comments. If you can see there, it talks about the public comments, click for additional member and public comments received. That's where you go and read them. That's there. We owe it to those members of the public and to members of our board and bar to listen to what they have to say. Last year, I think immediate past chair Jerry Alexander said this better than I could. Normally, this meeting would be our first meeting of the year. We've already had two, so I know you're already sick of hearing me talk, but this is our first scheduled called meeting. And Chair Alexander said that leave it to the bar to have our first meeting where we're already picking the leadership for next year. So I am soliciting folks and directors that want to put their name in the hat for the chair. The board policy states that a second-year director who desires to be nominated for the position of chair shall notify the chair in writing before the second quarterly board meeting of his or her intention to seek that position the following organizational year. Those interested should include a written statement that they believe would be informative to the board in its selection of the chair. If you are a second-year director interested in serving as chair next year, please send the letter of intent and your statement to me by Friday, December 11th. Do not wait until December the 8th to try to start writing your statement. It seems like a long way off. I will tell you from experience, don't wait that long to send it in because something will pop up. You'll have a hearing, you'll have a deposition, you'll have a family emergency. Get it out there. Get it to me, all right? If you need help with what that looks like, call me, call Jennifer, call Chelsea. We'll get you the resources that we need. Several of you have talked to me about that. We have a great group of second-year directors. However we go is going to be fine. If you do have questions, I hope you have found me to be available to answer those. Please reach out to me. Okay, we're looking forward to that. What will happen is you will give your speech, for lack of a better word, at the January meeting. The board will already have received your letter of intent. Then we will vote at the April board meeting. I have two things I want to talk to you about. One is board meetings, future board meetings. They are already scheduled. They're on the calendar. They've been on the calendar. Our directors, I know each and every one of you knows this, but I need to say it. It is a privilege to serve on this board. You sought election or appointment. And our rules state that if you have 2 unexcused absences in a row or 4 total absences in your term, you may be replaced or may be asked to step down. I don't want to see that happen. Please make being at these meetings a priority. I know the time that each and every one of you have already spent this year. This is our 3rd meeting now since July. It is our 2nd meeting in, I think, 2 or 3 weeks. I know the effort you've been putting in, but please make an effort to be here. Our board, our bar, and the members of the public deserve that. Finally, I want to talk about our communication with the public and our communication with each other and our communication with other lawyers. We lost Chief Justice Ginsburg, Ruth Bader Ginsburg, last week, and Whether you agreed with her ideology, her interpretation of the Constitution, her political views, her dissents, or her opinions, I don't think that it can be argued that she left an incredible legacy as a justice of our Supreme Court. And a friend of mine, Morgan McPheeters, sent me some words and about Justice Ruth Bader Ginsburg, and I wanted to share them with you. And I think that if we adopt these words, and if we listen to these words, I hope that we can begin a process of healing. The last 3 months have not been easy. This has not been an easy time for our bar. We are not always going to agree with each other. We're lawyers. Our entire purpose as lawyers is to protect our clients' interest, and the majority of that time it is spent fighting on behalf of our clients. That's a good thing. We enjoy self-governance. Our lawyers in our state, one of the most important things we can do as a bar is protect our right to self-govern. We fight for that. We fight for our clients. And we're going to fight with each other. But I'm calling our directors to do so with civility, whether that be in these meetings, whether that be in person, whether that be online and social media, to do so with civility. I'm not talking about the content of your speech. I'm not talking about the ideas that you wish to push, but I am asking you to show our bar and show our public and show our lawyers that we want to heal. Justice Ruth Bader Ginsburg said that reacting in anger or annoyance will not advance one's ability to persuade. To fight for the things that you care about, but to do it in a way that will lead others to join you. Real change, enduring change, happens one step at a time. She says, so often in life, things that you regard as impediment turn out to be great, good fortune. We've had a lot of impediments this year. We've had COVID. We've had infighting. We have an opportunity, though, to turn this into great fortune, to show Texas lawyers, to show members of the public that we are the leaders that we claim to be, to show that the State Bar benefits its members and the public. I am calling our directors to be the examples of the leaders I know personally them to be, and to do so with civility. Disagree, but let's do it the right way. I appreciate you allowing me that moment, and I promise I won't preach to you anymore. With that, are there any comments from the board about my report? I'll look on the hand raising, and let's see, turn that on. I see two. Director Smith, the floor is yours. Oh, before you go, Jason, I'm sorry. Let me just say that, as always, I'm not going to limit anyone's speech and time unless it becomes abusive in content or time. I ask that you direct all comments to me and no crossfighting, and that we let all folks that want it, all directors that want to speak, the chance to speak before you come back and speak again. Director Smith, the floor is yours.
Thank you, Mr. Chair. I appreciate your comments about Justice Ginsburg's professionalism and how she treated others with respect. And I think we all can learn from her relationship with Justice Scalia, with whom she certainly did not share the same view of the Constitution on most issues, but they had such a close personal relationship that it really is a great example of professionalism, where lawyers can be zealous for the positions they hold, but they can treat one another with respect. And I'm going to recommit myself to that, and I appreciate your comments in that regard.
Thank you, Jason, and I agree with you. I think that friendship and that relationship was a great illustration of what that looks like. Director Steve Fisher, you have the floor.
Good morning. First, technically, Spectrum in my neighborhood in El Paso is out till about noon your time, and I was here and present, and I just faded out. I don't know if Sylvia or Andy, they live in those fancy neighborhoods, whether they have their Spectrum or their internet. About the outreach, I mean, that sounds great, Charlie, but I'd like to put some teeth in that. What happens is, I'm sure many directors get invitations to speak all over the state. I've done about 4 or 5 free CLEs in different places. What I would like to enhance that is just have a policy with the CLE committee or the CLE people, Ms. Bauer, that when a director speaks at some place, that they don't have to go through all the paperwork, and an organization will call me, the federal bar, will you speak? And they have, a lot of them don't have all the mechanisms for CLE, and there's fees. So that should be waived, so that I agree with you, our directors should get out and talk to people. So if we can have that policy to make as little paperwork as possible whenever a director speaks to any bar organization, that would really help. Otherwise, it's just words. Thanks.
Thank you, Director Fisher.
The board vote. The board vote, because unless my internet gets on, I can't access my board packet. I'm using a hotspot.
Well, let's hope your internet works, Director Fisher. Director Hurst, you have the floor, sir. Hey, Michael, you're muted, my friend.
Thank you, Mr. Chair. First off, I'd like to say that your remarks were spot on, and the comment that I was going to make actually was stolen from me by Jason Smith. I thought the relationship between Justice Ginsburg and Justice Scalia is in fact a model of the behavior that we as lawyers should be following, and I thought that was crazy that he came up with that. In a time of partisan politics and hatred and dissent, I think that we as lawyers, we as leaders in the Bar Association need to do exactly what was just stated, and that is we need to set the example of professionalism, civility. We need to be the role models, not only for the lawyers in our state, but also for the citizens and other leadership in the state. I'd also like to point out one other thing, and that is in this time of COVID and this time of frequent shelter in place, many people in general and many people from our profession are suffering from depression, mental illness, loneliness, and things like that. And I think it's important and incumbent upon us to reach out, to stay connected, and to make sure that we watch out for our own as well as members of our community. Thank you very much for the beautiful words, Texas Treasurer, and I'm looking forward to the rest of this meeting.
We're going to have to put a stop to that. I don't know if I need to pass a resolution. That's going to need to stop. So just let the record reflect. In a world where nicknames take off, that does not need to be one. Director Cardenas, the floor is yours.
Thank you, Mr. Chairman. Mine is more a question than a comment. I think the fact that we have members of the public, including our own lawyers, come to speak to us is great. It shows that they're interested in our work and our bar. And speaking of civility, I think part of civility is respect. And I asked this question only because this is my first year and I don't know what the process is, but do we actually respond to them after they've spoken to us, either in letter form, thanking them, or some other matter, to show that we've not just heard them, but we've listened to them. We've passed their thoughts or comments on to a committee or somebody to study, and then get back to them so that they know that we are listening and that we're here for them.
Director Cardenas, I think that's a very appropriate thing to do. If a member of the public or the board or the bar, I keep saying board, if a member of the bar or the public reaches out to you with a comment, I certainly said I would think it's more than appropriate to tell them, yes, thank you so much for your comments. I will read these. I'll get these to the appropriate member. And if you ever have a question about that, Lowell Brown in our communications department, John Sermon, Chelsea, Jennifer, Kaylin, Ray, Trey, anybody would be happy to walk you through that here at the office. Call me. I'll get you in touch with whoever I need to. I certainly don't have all the answers, but that's where I would start. I hope that answers your question.
It does. Thank you. And thank you for your leadership.
Thank you, sir. All right. I need to go back and make sure we get our consent agenda taken care of. So I need a motion and a second to approve the items on the consent agenda. Any director who wishes to second, please ask to unmute, state your name. Do we have a motion?
I so move.
Director Bim makes the motion. Do we have a second?
I'll second.
Who was that seconded? I'm sorry.
I said it, but I think someone else did too.
Director Forbes is our second. Thank you very much. All of those directors in favor, please respond by saying aye.
Aye.
Any opposed? Hearing none, the consent agenda does pass. With that, it is 10:27. We are going to move to the next item on the agenda, but we're going to take a quick break first. Why don't we take a 5-minute break and, let's just say 10:35. So 10:35, we'll be back. Directors, please do not shut off your computers. Mute yourself, shut your camera off. It is 10:27. We'll be back at 10:35. Thank you very much. All right, welcome back. It is 10:35 and we're going to call the meeting back to order. As before, if any director wishes to speak on any matter, please use the raise your hand function, which is on the participation button. With that, we're going to proceed to item number 9, the report from the executive director, Mr. Trey Atfel.
Thank you, Mr. Chair. Good morning, board members and members of the public. I want to give you an update on State Bar developments and operations. Beginning first with a general COVID-19 update. We remain fully operational as staff and our staff continues to work remotely from home. We continue to maintain our COVID-19 webpage at texasbar.com/coronavirus as a hub of useful information and resources, including Texas Supreme Court emergency orders, as mentioned by Justice Lehrman, and also guidance from the Office of Court Administration. We understand how COVID has impacted many lawyers financially as well, and at the request of our own State Bar membership department, the Supreme Court extended the deadline for payment of membership fees without penalty by 2 months to October 31st, 2020, as Justice Lehrman reported. We also understand that the pandemic has made it difficult for some attorneys to complete their MCLE requirements on time, and in response to that, our MCLE department has granted several extensions to our attorneys, beginning with attorneys who had compliance dates going all the way back to November of 2019. The current compliance deadlines are available on our coronavirus webpage. Due to the ongoing spread of the coronavirus in Texas, Texas Bar CLE has been converting all live seminars to webcasts since April. So far this fiscal year, we've provided 38 virtual conferences in place of live seminars, and this includes multi-day and multi-track advanced courses. We've also heard feedback from our member lawyers relative to the cost of CLE in light of our moving to a webcast format. And I want to report that we have reduced prices for virtual programs by $50 to $200 below the price of the program had it been held in person. Even though these virtual programs do not require hotel and travel costs, they are still very labor intensive to produce, particularly when done in a way that maintains the usual high quality standards of Texas Bar CLE. And I want to thank our Texas Bar CLE team, beginning with Hetty Bauer, including Mary Volk, Pam Gilley, Virginia Izaguirre, and Paul Burks, and the entire CLE staff and team for their work and responsiveness to this issue. We are sensitive also to the fact that paying for CLE can be a challenge, especially during these uncertain times. In order to ensure that lawyers just beginning their careers have access to quality programs that we provide, we offer new lawyers a 50% discount off regular price of seminars, and lawyers age 70 or older receive reduced prices through our Flash CLE programs. We also provide free online classes and webcasts to our legal aid attorneys and attorneys providing pro bono services through Legal Access Division programs. And I think you saw from Dick Tate's comments earlier this morning, the passion that he showed for our legal aid, legal access efforts, that all of that is very important to providing those resources to our legal aid lawyers. In addition, for any lawyer still struggling financially and unable to cover the cost of a CLE program, we have our scholarship program in place. And to qualify for the scholarships, all you have to do is ask. So please take advantage of that if you feel the need. It's important also to understand and appreciate the fact that the State Bar of Texas relies on revenue from Texas Bar CLE to meet our financial targets and objectives. Course registrations and product sales are expected to generate sufficient funds not only to cover the expenses and overhead of Texas Bar CLE, but also to contribute to the State Bar's general fund to support programs and services that directly benefit our members. And revenues from CLE also have helped to prolong the time between dues increases, noting that the last dues increase was almost 30 years ago. This has resulted also in Texas lawyers paying the lowest dues of any large integrated bar in the country. So please be mindful of that. I want to bring you up to date on our Texas Bar Practice Member Services Benefit. Beginning in October, the State Bar is launching a new member service, and it's the new Law Practice Management website, and it's designed to help lawyers both do well and be well. The Texas Bar Practice website combines resources and functions that previously existed on the Texas Bar books and State Bar websites, while also adding new resources and a focus on lawyer well-being. You can access the website at texasbarpractice.com or through the State Bar website. On texasbarpractice.com, lawyers can explore a very robust collection of free management content produced by experienced attorneys. The website also offers articles, videos, forms, and tips on topics such as starting a practice, growing a practice, and law practice technology. Visitors to the sites can also shop for practice manuals, jury charges, desk books, and reference guides. And then lawyers can subscribe to the online practice manuals and access their library of subscriptions through their account on the site. Law firms have the option of creating their own accounts for their own organization that will allow their firm to manage their accounts and the resources used by their legal staff. This project is part of our continuing mission to support the administration of the legal system and enable Texas lawyers to better serve their clients. So I hope you will take the time and opportunity to visit texasbarpractice.com and let us know what you think. I want to give you an update on our TOGI program, or our Texas Opportunity and Justice Incubator. We are sad to announce that our TOGI director, Anne Marie Robigo, will be leaving the State Bar in the next few months to pursue other projects. We're going to miss Anne Marie, and we'd like to take a few minutes to recognize her accomplishment in launching the Texas Opportunity and Justice Incubator. She joined the State Bar on October 31st, 2016 as TOGI's first director. When she was hired, the Texas Opportunity and Justice Incubator was little more than a name and an idea. She was tasked with launching the program by April 2017, 6 short months from the date she was hired. TOGI launched in April 2017 in Austin with an initial cohort of 10 lawyers. In September of 2017, a second cohort of 10 lawyers joined. With the addition of the third cohort in March 2018, TOGI became the largest legal incubator in the nation. Here are the members of our first 4 cohorts. Many of these lawyers either moved to Austin or commuted long distances to Austin to participate. And then in 2019, TOGI became a virtual program able to admit lawyers from all across the state. In addition to expanding the program statewide, this transition also, as fate would have it, prepared the program to thrive during the unexpected COVID-19 pandemic. So pictured here are TOGI's first virtual participants from all across the state. As a virtual program, TOGI is able to welcome lawyers from across Texas, and TOGI participants serve clients in almost 1/2 of our Texas 254 counties. While most TOGI participants come from the millennial generation, as is shown on the current slide, that's not the only generation served. While some are new to the practice of law, Many are more experienced lawyers who are interested in launching a practice and in refocusing their careers to serve modest means clients. The TOJI program encourages diversity and inclusion, and in addition to a diverse racial and ethnic representation, 5% of TOJI lawyers are foreign trained and 11% are U.S. military veterans. TOJI, as you know, picks up where most legal aid leaves off and spans the modest income space of up to 400% of the federal poverty guideline. As of May 2020, TOJI lawyers had represented almost 5,000 clients in 35 different areas of the law and have saved Texans almost $3 million in legal fees. The Texas Opportunity and Justice Incubator has grown into the largest and most ambitious legal incubator in the nation. This effort ties directly in with the mission of the State Bar of Texas to assure all citizens equal access to justice and enable our members to better serve their clients. Another mission-driven program, in short, and it is a program that all Texas lawyers can be proud of. We'd like to thank Anne Marie Rabago for her service to the State Bar of Texas and for her dedication to closing the justice gap for modest means Texans. And we wish her well moving forward. And Anne Marie's just been a pleasure to work with, and we're going to miss her greatly, I can promise you. I want to talk to you about our Staff Excellence Awards. I want to recognize two very special people. The first is Ophelia Soto. Ophelia is an essential part of the State Bar's accounting team, and due to a promotion of one position and a retirement of another, over the past 3 years, Ophelia, who supervises the Cashier and Accounting Specialist 2 positions, has interviewed and trained 2 new accounting specialists and a new cashier, in addition to other temporary employees. She chose well, obviously, because her new accounting specialist 2 was promoted within a year, in part due to Ophelia's excellent training. However, this required Ophelia to once again take on extra work. In spite of a heavy workload and extra hours, when Ophelia hired her current team, she refused to rush their training in any way. Training made even more difficult because of the current off-site working situation. She has done this without complaint. Her work has continued to be done at an excellent level of accuracy, and her demeanor has continued to be extremely professional and helpful. Although she never seeks recognition for herself, Ophelia more than has earned this award. She exemplifies the notion of doing what it takes to get the job done. We are grateful, and the accounting department is fortunate to have Ophelia as a team leader. Thank you, Ophelia, for your commitment to excellence, and congratulations. Next is Zara Stanfield. Zara is a legal assistant for the Office of Chief Disciplinary Counsel, who supports the Supreme Court's Unauthorized Practice of Law Committee. These meetings are long, and they involve reports from dozens of members. With COVID-19, everything had to shift to a virtual format quickly. Co-workers report that Zara has become a technology expert in terms of running Zoom for the committee, making sure the votes are tallied through Zoom polling features, and making sure documents are ready to pull up and be shared with everyone in the meeting. Not only does she organize and host committee meetings under the new format, she also has taken on the added responsibility of hosting and organizing investigatory hearings by Zoom for the UPLC's subcommittees. Zara demonstrates her knowledge of the rules and procedures when called upon, is professional, and just shines in her role. The current committee chair, Chris Lohman, called Zara the glue that holds our organization together. Leland De La Garza, the committee's past chair, said, and I quote, "Zara has been our one and only full-time employee. She has carried a heavy load and done so without any complaint, even as we piled on more and more responsibility. She has always been available to us. I could not have found a better employee to handle the UPL committee's work." Thank you, Zara, for your commitment to excellence, and congratulations on a job well done. And next, I'd like to give you a brief update on our Texas Lawyers Assistance Program. I recently received a letter from the trustees of the Sharon Crowley Memorial Trust expressing their gratitude to the State Bar Board for its commitment of $225,000 to the trust. For those who don't know, the trust was created in 1995 to provide financial help to Texas attorneys, judges, and law students who need treatment for substance use, depression, and other mental health issues, but lack the means to pay for the treatment. The trust is administered by volunteer trustees who are members of Texas Lawyers Concern for Lawyers, an organization that works closely with our Texas Lawyers Assistance Program of the State Bar of Texas. In the last 6 years, the trust has funded treatment for almost 400 Texas lawyers, law students, and judges. Since the pandemic struck, the trust has given financial assistance to more than 100 lawyers impaired by chemical dependency or mental health disorders. Since 2011, the State Bar of Texas has provided almost $1 million to support the trust, which illustrates our commitment to helping Texas lawyers, judges, and law students. The services of the trust are more critical now than ever because of these difficult times. The trustees assure us that the State Bar's contribution will, and I quote, save careers, save families, and save lives. And from the State Bar of Texas, I say that we are proud to support them in this important work, and I thank this board for their continued support. And with that, I'll next call on Chris Ritter for a report from our TLAP program. Chris.
Thank you so much. And I just want to say the Sharon Crowley Trust is maybe the most important tool we have to help many people with mental health disorders, substance use disorders, to get the professional help they need. And I can't tell you, we process and help administer that and help work with that. And it means so much to us. We've helped more than ever. I can't tell you how many. This year, I can tell you we've helped more attorneys and law students than ever with that trust. And I'm going to share my screen because I have a very brief PowerPoint, but I wanted to share some really, I think, very important news. This is something, this has been a really tough time. And I just wanted to share with you all. The State Bar of Texas has been so supportive of TLAP. As you might imagine, with this epidemic, with the isolation that we're experiencing, the kinds of calls that we've been getting have been even more extreme than normal with mental health and depression and even substance use increases that have happened. But I just wanted to say, this has been a tough time for us all, even in the work. Our team, I'm so proud of. Being isolated, we're missing out on our normal ability to process helping others. We're missing out on the support we get from each other just walking around the State Bar. So this has been a unique time for self-care. I want to share some amazing things, and really a lot of this isn't TLAP's fault. It's due to some help that the State Bar, the executive team, Texas Bar CLE has given. One thing we've done recently in response to some suggestions from a couple of younger people and even a board member of ours, the committee member, we have added text messaging so that people can reach TLAP by texting us. There are a lot of attorneys and law students that prefer not to call. They feel like that's a difficult barrier to actually be that vulnerable. And this is amazing. We've helped 173 attorneys since we've implemented that last November, just through text messaging. That's a big deal. We've also been thriving, and I think some of the things we've changed since the pandemic started will be permanent. The use of Zoom, which we're sick of, everyone's sick of Zoom, but we're doing some really big programs on Zoom. And I just want to share this gets me choked up. There's nothing more important to TLAP than suicide prevention. And since November of last year, over 15,000 attorneys, 15,113 attorneys as of this past week registered and watched What Lawyers Need to Know About Depression and Suicide. That's a Texas Bar CLE program that we were teamed up with. But that's such a big deal because the Air Force showed 20% reduction in suicide rates with this exact type of training. Practicing law in the shadow of COVID-19, TLAP had a part in that, a self-care part, but 18,326 attorneys were reached with that program, many of whom were solo practitioners. We've also done, and just to put this in perspective, we've done 27 other presentations in the past few months with just in this quarter, not counting all the stuff above, 4,919 attorneys reached directly in those programs. And I just want to put this in perspective. For several years of my being at TLAP, 6,000 or 8,000 was a range annually for us getting to people, getting in person to people. And so we're really improving our outreach. Our numbers were 20% higher in the past calendar year. This year, we're up even a little bit above what we were last year. Just to put this in perspective, I believe we're really doing well because Pennsylvania, during the pandemic, they were down 28% in their calls. Our increased outreach, I think, has kept us steady with our increase from last year. We've also really worked hard recently to improve our service. We're going to be working on this whole year. We've always worked on wanting to improve our services to minority populations. But after George Floyd, we took it upon us to try to listen to the African-American lawyers. We're having October 8th a meeting with Latino and Latina attorneys to hear what might be, and we're going to do the same with LGBTQ attorneys to hear what might help us help improve our service to those populations. And this surprised me to find out a while back TLAP did, this has been about a decade ago, but I see no reason for this to have changed, a study that showed 80% of the people that we help at TLAP are solo practitioners. And so we're also going to focus on how we can better serve solo practitioners. That leads me to what we have done during the pandemic. Our support page, you can find it at tlaphelps.org, but we've done a number, about 20 individual quarantine support programs. You can watch these at any time. They're on video recordings. Boot camp for being at home, crisis fatigue, handling anxiety during the coronavirus. These aren't all of them, but these are most of the ones that we've done. They're all unique with mental health professionals, along with our TLAP team doing these. We're very proud of I'm so proud of the team. Erica Grigg, Shauna Story-Lovin, and myself are the three professionals. Erica is an attorney, I'm an attorney, Shauna is a therapist. And between the three of us, we have done enormous work. We also, and I'm going to share very quickly right now, have focused a lot on our own self-care because burnout for mental health work can be extreme, and for attorneys in general, burnout can also be very high. I am going to show you what the quarantine has done to us with mental health. This study shows that among 129 participants, 29% had PTSD symptoms from just being quarantined, and 31% had symptoms of depression. Likewise, these other studies, there's 24 studies showing quarantining develops mood, anxiety, and depressive disorders. A third of Americans have in another study reported a serious impact on their mental health. This isn't anything that we'd be surprised by, but looking at the fact that attorneys are already handling so much anxiety, this isolation is dangerous to our mental health. 46% of attorneys in a study in 2015 of 13,000 attorneys responding, 46% admitted that they had struggled with depression. And this is before the pandemic. So I just want to say, this is the most important thing we can do is try to share self-care strategies, how to get through the pandemic. I want to mention right now, just because I think even this board are made up of attorneys and could use just to hear just a moment. In 3 minutes, I'm going to share 4 healthy habits that have helped us get through at TLAP some really difficult work. One is, and we're zoomed out, but connecting and debriefing is really important. We're actually having meetings, if not weekly, every couple of weeks, to just talk about what we're going through, what we're struggling with, the silver linings. Just to be able to talk about what's hard right now with someone is really important. First responders have to do debriefing all the time, but stay connected. Don't let the physical barriers be a social barrier. Another one is really important, is learning to activate your parasympathetic nervous system after getting stressed out. So every morning you're going to go in and check your email, or you're going to have a stressful hearing, or you're going to have some, we all have something that stresses us out, usually to start our day off, opening the mail. And if you don't do something physical after being stressed, your nervous system stays where it's at. Activating your parasympathetic is getting out of the fight or flight sympathetic nervous system. And in order to do that, we can do many things physical. One is breathing exercises. Look at this, in 2 weeks, from the 90th percentile for anxiety. By the way, in law school, we're in the 96th percentile. 90th percentile for anxiety to the 57th in 2 weeks, just focusing on the breath. It's just like a light switch. You turn it off. There's many other things. Just walk around the block after a stressful phone call or after a hearing, or any of these other things you can do to get back to your parasympathetic. If you don't turn it off, you're going to have chronic stress, and that's what's going to can cause anxiety disorders, and it can result in the kind of stress exhaustion that can contribute to depression. Setting boundaries right now is really hard. I'm sitting right now 20 feet away from my 6-year-old daughter, who's in there on Zoom in school, and I'm in my dining room. And setting boundaries is hard right now. Here's a few suggestions. With technology, check your email a few times a day instead of the average person is checking our iPhone 150 times a day. So just check it early in the morning before noon so that you don't constantly let it check you. Many of us have our notifications set that it just dings every time there's a new email. So you can be checked. We're averaging 120 new emails a day, so you could be getting interrupted 120 times a day. If you do that, limit your social media to 10 minutes per platform. This study shows if you limit it to 10 minutes per platform, you actually have no mental health effect in this study. So put a timer on it. We're using our clock timers. Monitor your use by using screen time. Use do not disturb. Turn off your notifications. It's actually really easy to do this. You can go to settings, and then you go to just push the notifications button, and it has all of your apps. Only leave on the notifications for the essential. And then don't charge your phone beside your bed. I'm going to stop now with this. This is a time where everything seems to be wrong. Attorneys are trained since law school to see the problems out there, one of the skills we need is to see the risks by seeing what could go wrong. And when everything seems to be not going great in the world, it can be really, it can bleed, our skill of seeing all the problems can actually bleed over and affect our happiness. Gratitude practice is scientifically shown to offset that. If we can just think every day when we start our day, think of 3 things. It takes less than a minute that we're grateful. 3 things that we're grateful to have in our lives. One study shows 25% increase in happiness, but it keeps our positive mind from atrophying. Gratitude practice is really important right now. I want to share a picture of the team I'm so proud of. This is our group. All of us have maintained wellness through this difficult time and have done a great job. If anybody needs anything, we're here, and I'm so glad and I'm so honored to be able to share this. Thank you so much, Trey and everyone else, Texas Bar CLE, for what you've helped us accomplish.
thank you, Chris, for the work that you and your team do. It is an incredible resource. I know State Bar Board of Directors we appreciate all that you do. Thank you for your report. With that, let's go to item number 10. Justice Deborah Hankinson, are you with us?
I am with you.
You've got the floor, ma'am.
Thank you. I apologize for not being on camera, but my camera failed. A new one is on the way, but it did not arrive in time for me to have it to make this presentation to you. I would like to thank the board for inviting the foundation today to give a brief report on how the foundation is being creative during these difficult times of COVID and its consequences and the racial equity issues that we are all dealing with. I am pleased that the Supreme Court appointed me to become the new chair of the foundation, and I am pleased to be working with board members Joseph Barrientos, who will serve as our vice chair, Roland Johnson, who will serve as our treasurer, and Terry Tottenham, who will round out as the fourth member of our board executive committee. I would like to first publicly thank Dick Tate for his incredible years of service to the foundation and to providing access to justice to the people of Texas. We greatly appreciate that the board has recognized Dick today through a resolution. I am first pleased to report that the foundation's board, through years of thoughtful work and dedication to a diverse board, as of September 1st, is made up of a majority of people of color. This is a big accomplishment, and we are extremely proud of this effort. It is an excellent board with a mix of diverse backgrounds and ideas. This could not have happened without the help of the State Bar of Texas and the Supreme Court. The State Bar and the Supreme Court are who make our board appointments, and we appreciate how through the years you have listened to our thoughts and recommendations as we have worked toward achieving this goal. We would also like to thank the Hispanic Issues section, its chair, Judge Villarreal, for hosting a fundraiser on Dies Acies La Teria, which highlighted Hispanic leaders and raised dollars to help those impacted by COVID-19. Thank you to State Bar President-elect Sylvia Borunda Firth for being the host of this event. Thank you to the State Bar board members who sponsored or donated. So far, $40,000 has been raised, but let me assure you, you still have the opportunity to give. We would ask the State Bar to please put this link to this funding operation in chat. The need is huge. Also, many thanks to Justices Guzman and Busby who participated. As you all already know, this has been a tough funding year. When interest rates first plummeted in March, our IOLTA revenue was devastated. We immediately lost $1 million a month in revenue that we were counting on until the crash of the interest rates. The consensus is also that this will be a tough state budget year. We are pleased to report that the Supreme Court has taken the bold step of asking for more dollars, recognizing that more people have fallen into poverty. The newest report is that over 3 million Texans have filed for unemployment since the beginning of the pandemic. And we are hopeful that with the support of the Supreme Court and the State Bar, that the legislature will be responsive to our request. Finally, we would like to thank the Supreme Court for submitting a CARES Act request on behalf of the foundation. We expect official word to come soon. We would like to express our thanks and appreciation to Justice Guzman and Chief Justice Hecht, who championed this effort and the entire Supreme Court's support of that effort. With that, let me just say that the continuing support of the State Bar of Texas to the work of the foundation is critical to our being able to deal with the issues that both COVID and the racial equity issues that have come to the forefront recently for our continuing being able to try to meet these challenges. We could not do so without the support of the State Bar. So thank you for all that you do.
Thank you, Justice Hankinson, for the work that you're doing, and we're excited about your leadership and for all that the Texas Access to Justice Foundation does. Thank you. We're looking forward to a great year. With that, we're going to move to item number 11, report from the president. We are going to take this a little out of order. We are going to start with item number H, which is our Judicial Conduct Commission. Here in just a few minutes, Larry will give an overview of the State Commission on Judicial Conduct appointment process. If anyone wants to speak, you'll be told that you'll be giving 2 minutes per speaker, and the candidates for those will be introduced after Larry gives his introduction, and we will go from there. Mr. McDougall, the floor is yours.
Thank you, Mr. Chair. We'll move to action item number H. This is the election of appointee to the State Commission on Judicial Conduct. This is for an unexpired term that's effective January 1, 2021 through November 19th of 2025. This is the position that Steve Fisher currently holds. For those of you who don't know, the State Bar Board appoints 2 members to the State Commission on Judicial Conduct. The other member is currently Ron Bunch, and I believe that he was appointed during Tom Vick's year. This vacancy that we currently have became available when Director Steve Fisher resigned from the commission. The resignation letter from Director Fisher and our acceptance of that resignation, as well as other reference materials, are included on our board effect under agenda item number 11, if you would care to read those. The Judicial Conduct Commission is a Texas state agency responsible for investigating allegations of judicial misconduct. The commission is made up of judges, public members, 2 practicing lawyers who are appointed by the State Bar. An email was sent to the board on September 9th from Jennifer Reams describing the appointment and the process that we go through. The appointment process for the Judicial Conduct Commission is outlined in a 2017 Texas Supreme Court order. As required by that order, myself, the president, and the chair, Charlie Ginn, of the board are to confer and nominate 1 or more qualified lawyers for that position. Charlie and I did confer, and I believe we both interviewed Clifton Robertson of Tyler, and he will be the nomination person nominated by both the chair and the president. Just so you know, Mr. Robinson is an African-American, and the makeup of the current commission, there is 1 other African-American currently serving. So if Mr. Robinson is approved by this board, he will be the second. The Supreme Court order also allows board members to make additional nominations by notifying both myself and the chair in writing no later than 10 days before this meeting. 2 additional candidates were received for consideration. Director Miller out of Corpus Christi nominated David Klein of Corpus Christi, and Director Luis Cardenas nominated Ernest Aliceta of Edinburgh. There are now a total of 3 nominees up for the position, and the board must choose which one of these candidates by a majority of the vote. So we have 3 candidates under consideration. That's going to be Ernest Aliceta, David Klein, and Clifton Robertson. The resumes for these nominees are in the board packet. The appointee again will serve the unexpired term beginning January 1st and ending in 2025. Mr. Chair, at this time, I turn this back over to you to conduct the election.
So the way this will work, here in just a few minutes, we will have those that nominated the individuals introduce them and make whatever comments they see fit. After that, I do see some hands that are raised for those directors to speak out on behalf of the candidate of their choosing. Your comments will be limited to 2 minutes, just in the interest of time for this. The resumes have been posted. You will not hear from the candidates today. That is something that we in the past have not done and will not be doing it again today, but we'll be hearing from those that either know or nominated them. We will go through the process of that election, about the election after the comments of that. I am abstaining from the vote. As chair, I'll vote in the event of a tie, but otherwise I will be abstaining. And let me talk to you a little bit about Clifton Robertson. To do that, so I follow the rules, I'm going to yield the chair for a few minutes to immediate past chair, Mr. Jerry Alexander. Jerry, are you with us?
Yes, sir, I am. I accept the chair.
All right, Mr. Chair, I'm here to talk to you about the nomination of Clifton Robertson that President McDougall and I nominated. When looking at this appointment, we looked at several things. When we talk about demographics, we do look at things like race and gender and age. But also when you look at demographics, you look at other areas as well. Geography, size of law firm, practice of law. And in this case, Mr. Roberson is a qualified candidate for this position. He is a solo practitioner from Tyler, Texas. He practices criminal defense, and he is an exceptional lawyer. He has an incredible reputation. I have spoken with members of the Smith County Bar. I have spoken with people from Tyler, and they assure me that his reputation is without equal. He has been practicing for over 30 years inside of a courtroom. And so when we look at who we want to represent us on this commission, I am confident that he will do so with honor and with integrity. I do want our board to know, and I spoke with Mr. Roberson again last night about this. In 2013, this is public record, and even a news article was posted about this. Mr. Roberson was held in contempt and arrested by a judge. The reasoning and rationale for that is explained in the article, but let me just tell you the circumstances of that. Mr. Roberson was making a criminal appearance on behalf of a client when he learned that a family member of his was on their deathbed in Tyler. Mr. Roberson notified the court that he would not be there. The court received notice of that. While he was at the hospital, the court called, my understanding from the article, and said, "You need to be here in a few minutes. If you're not, we'll arrest you." Mr. Roberson stayed with his family member, and ultimately he was arrested. When I talked to Mr. Roberson last night, he said, "Listen, tell the board about it. I'm open about it. In fact, I'm now friends with that judge." And I said, "Mr. Roberson, there could be a concern that maybe this could look like we are trying to nominate someone that has a vendetta against judges." And he said, "That is just not the case. Every interaction I've had with Mr. Roberson, he has proved himself to be a gentleman, to be a man of honor, and that has been seconded by those that have practiced both with him and against him. It is my opinion that he would make an exceptional candidate for this position, and I believe that President McDougal has joined with me in that opinion. I would tell you that I am not concerned about the altercation that he had with the judge. This is a position that a lawyer that has been prevalent in the courtroom for the last 30 years is very qualified for. He is the first African-American assistant district attorney in Smith County. I practiced criminal law before I went into personal injury, and I will tell you that my understanding is Mr. Roberson has seen it all, done it all, is a gentleman, and would make an exceptional candidate for this position. With that, thank you, Mr. Chair. Alexander, that's all I have, unless Mr. McDougal has any other comments.
No further comments.
I yield the chair back to you, Mr. Chair.
Thank you very much. With that, I'd like to turn it over to, let's see, Ms. Miller, are you on the call?
Yes, Mr. Chair.
All right. Would you like a few minutes to talk about your candidate?
Yes, please. And thank you.
You've got the floor.
Thank you. I have the privilege this morning of introducing Mr. David Klein as a candidate for appointment by this board to the State Commission on Judicial Conduct. Mr. Klein is a double Longhorn, graduating with a degree in finance and subsequently with a Juris Doctor from the University of Texas. He became licensed to practice law by the state of Texas in 1998. Mr. Klein is a lawyer in my district, District 11. Although his primary practice area is here in Nueces County, he's practiced in many counties in Texas and has practiced extensively in the counties in between Houston and the Valley. Relevantly, Mr. Klein is married to Judge Ina Klein, who presides over the 214th District Court of Nueces County, Texas. If elected by the board to be appointed to the State Commission on Judicial Conduct, Mr. Klein will bring that distinctive perspective to the commission. Mr. Klein is a solo practitioner. His experience in the practice of law is broad and uniquely varied. He has tried to verdict more than 45 jury trials regarding capital murder, violent and sexual offenses, and federal conspiracy cases. In addition to criminal law, Mr. Klein also has experience in the areas of family law, insurance defense, medical malpractice, personal injury, municipality defense, and general civil litigation. Mr. Klein's experience also includes representing professionals accused of wrongdoing, including and importantly, representing judges before the State Commission of Judicial Conduct. Because of Mr. Klein's comprehensive experience in geographic location and in practice area over his 22 years of practice, he is an ideal candidate for this position. Further, because of his experience in representing clients before the State Commission on Judicial Conduct, Mr. Klein will be ready to hit the ground running with a minimal learning curve as to serving in this incredibly important capacity. I believe he will represent us well. Thank you, Mr. Chair.
Thank you, Director Miller. Luis Cardenas, are you with us?
I am.
All right. Would you like a few minutes to talk about your nominee?
Yes, thank you, Mr. Chairman.
The floor is yours.
Thank you. And members of the board, I nominated Ernest Aliceda because I really think he's an ideal candidate for this position, for the Texas Commission on Judicial Conduct. I've known Ernie for a long time. I can attest that he is a genuinely good person, a good human being, and professionally, Ernie brings, a lot of integrity and character to the practice of law that he's been doing for several decades now. But really, as it relates to this particular position, Ernie really brings vast experience to this from his practice that I think would really benefit the commission if he were to serve. Ernie has served as a board of, as a regent on the University of Texas System Board of Regents. And in fact, he's happy to say that he's the first Aggie to ever be appointed to the UT Board of Regents. Ernie has served as a judge multiple times. He has served as a district court judge in 2 different courts. He has served as a municipal court judge. And interestingly, he's also been a trial judge on the U.S. Army for the United States Army. And he has served in this capacity because for decades, Ernie's been served in the U.S. Army Reserves and has done many, actually participated and been called into active duty multiple times during his decades of service in the U.S. Army Reserves, including service during Operation Enduring Freedom. And so he's actually been and served as a judge in so many different capacities, both state district court level, municipal court level, U.S. Army trial judge. So just brings an incredible amount of background to the Judicial Commission and his potential service there. Everywhere Ernie served, he has been a person he has served with distinction. As you can tell, if you were to look at his CV, for his time in the military, he's been awarded Meritorious Service Medal, Commendation Medals, Army Achievement Medals, Reserve Achievement Medals, Global War on Terrorism Service Medals, and National Defense Service Medals. So it's really an incredible career and service that Ernie has always been a part of, including prior service on this as a director on the State Board of Directors, on the Texas State Bar Board of Directors. He has been also awarded the Jim Bomer Professional Service Award by the Texas Bar College. And so in every respect, this board can have full confidence that they are voting for a highly qualified person, that he will serve with honor, with integrity, and very importantly, that they are voting for a person with excellent judgment. And he always exercises good judgment. So a board member can know that with their vote for Ernie, that they will never regret that vote, and they will never be second guessed by sending Ernie into any capacity, including the Board of Judicial Conduct. So for these reasons, I nominate and I strongly recommend Ernie Aliceda for this position. Thank you, Mr. Chair.
Thank you. All right. So now we're going to move into the comments by the directors. You're going to be limited 2 minutes per comment. And unless there be a good reason, probably not repeat, come back around and repeat. So we'll just hear comments from everyone once. These comments should be directed about the candidates and their capacity to serve. In the past, we have had friendly only comments. I'm not going to restrict it to that. So if you have something to say it, but I would ask you to do it in a respectful way. That said, we will start with Director Jason Smith.
I apologize. I had my hand raised for the previous discussion with Judge Hankinson.
Director Smith, I'm sorry then. I didn't see that. And if you'd like, at the end of this conversation, we can swing back around to you.
I'm okay. Okay.
All right. Thank you, Jason. Director David Calvillo.
Yes. Thank you very much. I'm really very excited to be able to share with my fellow directors a little bit of insight into my longtime friend and former law partner, Ernie Aliceda. This is the strongest recommendation that I can give. I share with you today on behalf of Ernie. As you could hear from Luis Cardenas, his credentials, which by the way are at page 698 of our 1,045-page packet. I direct you to that. I think it speaks for itself. You can see though from those credentials that he's not perfect. He's not perfect because he's an Aggie who served on the UT Board of Regents. But I think it reveals the content of this man's character. If I was starting a law firm today and I could choose one person to be my partner, to be there in the trenches, there are many of, I'm privileged to have practiced law with a number of fine individuals, including the ones that I practice with now. But Ernie would certainly be in that list of 2 or 3 that I would give a call and say, let's go. Ernie is appropriately named. His full name is Ernest or Ernesto. And there's no better word than I can describe Ernie as saying he is earnest. Earnest and genuine are characteristics that everybody who meets Ernie knows that he exemplifies. As the only candidate with judicial experience of the 3, I'm sure the other 2 are fine individuals, but Ernie is the only one with judicial experience. I would also point out that if you look at the roster of current members of the Judicial Conduct Commission.
Mr. Calvillo, please finish your thought.
I will. He is the only one of the members that are on the board at the moment. The furthest south, the person that is from the furthest south is from Kerrville. So if geographic diversity is important, if credentials and the content of character are important, then I would suggest that Ernie Aliceda is by far the best candidate. Thank you.
Thank you, Mr. Calvillo. Director Forbes, you have the floor. Your 2 minutes starts now. Are you, Lucy, you with us?
Oh,
all right,
yeah.
Your 2 minutes starts now.
Okay. Thank you. Okay. In the spirit of transparency and reform, I'll have to borrow from Justice Ginsburg. I have to dissent. I learned yesterday for the first time that the State Commission on Judicial Conduct candidates do not actually address the board at this meeting before the board votes. I'll be honest, I was appalled. We as the state bar only get 2 positions, 2 guardians on this 13-member commission who serve 6-year terms. Now, the vast majority of judges are exemplary, but there may be a handful that berate, humiliate, shame, belittle attorneys and parties on the basis of their gender, skin color, national origin, race, accent, or for any other arbitrary reason untethered to the merits of their case. I challenge us as a board to question the systems in place. Some are traditions since 1939, and to ask, does it still serve our mission in 2020. There's nothing that prohibits a candidate from addressing the board. I checked Constitution, Government Act, Bar Act, Bar Rules, Policy Manual, and the Supreme Court order of August of 2017. It actually requires the board to choose. I do not seek to delay the vote. I ask only for the opportunity to make a fully informed vote and for the candidates to feel they have been heard by the opportunity to address us.
Please finish your thought, Lucy.
I encourage that after the president, chair, or director introduces these outstanding candidates, that we then hear from the candidate themselves. So that is my suggestion and challenge to us as the board to consider. Otherwise, I have no comment to the candidates themselves. And as I say, I do not seek to delay any vote. And I appreciate the time to express my suggestion. Thank you.
Thank you, Director Forbes. For the remainder of the speakers, I don't want this to become a discussion about procedure. I want these comments to be about the candidates themselves for efficiency's sake. To address Ms. Forbes' comments, I think one of the reasons that we do not hear from the candidates is my belief is such that this is not a position that one should campaign for. This is something that should be selected and nominated by others. And so the resumes have been included in the packet for at least 7 days. The chance to nominate others after the president and chair agreed on a nomination was, I believe, 5 days after that. And each director had an opportunity to nominate a person for this position. So just to address some of Mrs. Forbes' comments on procedure, not commenting on whether or not she's correct or not. Director Naylor, you have the floor, sir.
Thank you, Chairman. Mine is not about them. I would need to ask a question of each person who nominated one of these people. And forgive me, I need to ask Trey, Randy, Larry, and any others in authority. We are having to replace a director who did not commit to serve his full term. I want to know if these people have committed to fill and serve the full term. It turns out at the last election that we turned down a very qualified person. We were not told that Director Fisher had no intention of serving out the full term. And that's something that should have been told to the voting members of the board. I feel like in this time of lip service to transparency, especially by Mr. Fisher, that we were not told the truth. That might have very greatly impacted who we voted for if we had known that he had no intention. So I'm asking the chair, since we have to direct our comments to you, Chairman Gim, to ask those that have nominated them, have they said they're going to serve the full term? And if any of these published reports that they do not intend to serve the full term, because I was very highly offended that we were misled last time. I yield to you.
Thank you, Director Naylor, and I understand your concern and frustration. My understanding is that all three candidates have indicated their willingness to serve a full term. I have not spoken to all the candidates, but I have not heard anything to the contrary. And so at this point, unless Ms. Miller or Luis wants to indicate otherwise, I think that should answer your question. But I understand the frustration, and I appreciate the comments that you've made. Is there anything else, Director Naylor? Okay, I see you shaking your head. Thank you, sir. Director Davis, the floor is yours.
Thank you, Mr. Chair. I would like to take a minute today to speak in support of Mr. Clifton Roberson, who is an attorney in my district, but I don't want you to just hear my own words, so I've compiled statements provided to me by Mr. Roberson's colleagues. These are statements from judges he has and does appear before, prosecutors who have worked with him and against him, and his fellow attorneys. I'll start with, I've known Clifton Roberson for more than 20 years. He has practiced as a prosecutor and a defense attorney his entire career. We have had cases where we opposed each other and cases where we have represented co-defendants. I appeared as a witness in an attorney disciplinary hearing when Clifton was on that panel. I have examined Clifton as writ counsel in post-conviction matters. Through all the years and all the circumstances, I have known Clifton to be honest, forthright, kind, and fair. Clifton does not seek fame, notoriety, or acclaim. He seeks what is fair, reasonable, and just for his clients and for our profession. I recommend Clifton Roberson to serve on the State Commission on Judicial Conduct without hesitation. Clifton has served Smith County many years as a criminal attorney, both as a prosecutor and a defense attorney. While he represents private clients, he has represented indigent criminals for many years, always doing his best and trying his hardest to provide excellent representation. I have known Clifton for over 20 years, and he has always shown integrity, professionalism, and courtesy to all parties involved in the judicial process. Clifton is a great advocate for his clients. The thing I most admire about Clifton, however, is his love for his family. He often speaks glowingly about his wife and children and is a dedicated husband and father. Clifton seems to have found the perfect balance of being excellent at his job and at home. Mr. Clifton Roberson has spent decades defending the constitutional rights of those less fortunate members of our community. He has worked countless hours to bring his experience and talents to make sure each of his clients receive the full measure of protection under the law and fairness in our courts.
Thank you, Ms. Davis. You can finish your thought, please.
Thank you, Mr. Chair. I could keep the board here all day with my comments praising Clifton's legal career and his character. I can summarize the rest of the statements I received to state that Clifton is well-respected, professional, dedicated to justice, and above all, kind, which I think after a long legal career is a virtue to be highly praised. The mission statement of the State Commission on Judicial Conduct includes in its aims, among other things, to protect the public and promote public confidence in the integrity, independence, competence, and impartiality of the judiciary. It sounds like Clifton has been doing just that his entire career. Thank you.
Thank you, Director Davis. Director Fisher, you have the floor.
Okay, I might need a little more than 2 minutes. First, in
That's 2 minutes, Steve.
I need more, I'm sorry. In response to Mr. Naylor, I made it abundantly clear on Facebook and everywhere else that I was not going to serve 6 years. In fact, the other person for the position, Christy Nolte, I wrote her, I messaged her, I said, look, how about I do 2 years and you do 4 years, I do 3 years, I would be 76 years old in a 6-year term. In addition, there's so much turnover. There was about 6 people who left just during the first 6 months. And I asked, one of the members from Houston, I go, why is nobody stays 6 years or 4 years or 5 years? And he goes,
Director Fisher, listen, I'll make you a deal. I will let you go longer than 2 minutes after we get done discussing the candidates, but unless you have a comment about one of the candidates, we're going to move on to those discussions because that's the purpose of this agenda. Do you have it? Hold on. Do you have a comment about one of the candidates?
I have comment about all the candidates. I'm not taking sides, but just some things that people need to know and that the candidates need to know. And of course, if I was invited to speak the last time, I would have solved Mr. Naylor's problem. But I don't mind waiting till the end. But
okay, if you don't have a comment, if you do not have a comment about one of the candidates, we'll wait and hold till the end. Thank you very much.
Thanks.
Director Crane.
Thank you, Mr. Chair. For the board members to know that the commission is a 13-member body. We only appoint 2 of the 13. 6 are appointed by the Supreme Court. From the current roster, 5 of those 6 spots have been filled. They've all been filled with judges or justices. The other 5 members are citizen members appointed by the governor. So there are only 2 that we appoint, and only 2 are lawyers. Mr. Fisher now having resigned, there's only 1 who's a lawyer. Mr. Roberson did not seek this position. I want that clear. Because of what's happened in the past, we wanted to make sure we got a qualified candidate and went to the 4 districts. There were only 4 districts we could go to with this open seat because of geography limitations. Mr. Roberson's colleagues are the ones who brought Mr. Roberson's name to the forefront. It is then Mr. Roberson being approached and agreeing and appreciating the weightiness of this position. There are only 3 non-white members of this current commission. The next two to roll off are two of those three non-white members. One of those is the only African-American. Mr. Roberson would be the only African-American going forward. He has diversity of demographics, diversity of practice area, and diversity of geography. He is somebody that didn't come from one of us, it came from our members. I would and this was a process. This was not somebody coming to us to say, I want the job. This was not some group of directors going and finding somebody they wanted. It was our members who brought Mr. Roberson to us. All of these candidates are well qualified, but he
Mr.
is
Crane, please finish your thought.
He is the only lawyer, not formally a judge, not married to a judge. He will be one of only two attorney members, and that brings diversity as well. Thank you.
Thank you, Director Crane. Director Augusto. Benny, you're muted. As soon as you unmute and begin, your time will start. Yes, sir.
Thank you. Thank you, Mr. Chair. I'm just going to briefly speak in behalf of Judge Ernie Aricela because he is a judge and he fits the requirements of the different factors that we need to fill this position. I look up to Judge Aricela because of his long history of judicial conduct, of being a judge, of being a bar leader, and more importantly, also representing our country in his military. He's a retired lieutenant colonel in the Army. So what we look at in a person like this is obviously we have great candidates, and I'm not criticizing any candidate, but I'm speaking up for Judge Aricela specifically because it's a person that I have looked up to and seen his track record, and he will bring the proper temperament from the judicial side to help us work in the State Commission on Judicial Conduct. So with that said, I strongly encourage our members to vote for him, and I yield back my time. Thank you, Mr. Chair.
Thank you, Director Augusto. Yolanda, Director Cortez Maras, are you with us?
I am. Thank you very much, Mr. Chair. I don't have a comment with regards to any individual candidate that has been proposed, but I do have a general comment, and that is the commission is comprised of 13 members, 2 of which are women, only 2. One of those women is a public member appointed by the governor. The other woman, and that's Ms. Ertz, Valerie Ertz. The other member, Janice Holt, was also appointed by the governor. So my question is this: in the interest of diversity, is in particular gender diversity, were any women considered for this position by the board, or not by the board, but rather by you, the chairman, and by the president of the State Bar, Mr. McDonald?
Yolanda, I'll respond. I want to make sure any other questions, I can hit them all at once. Do you have any other questions, Yolanda?
No.
We considered several candidates. There were female attorneys included in that. There was a discussion. The opening for a director, for a position on this board was open to all directors to nominate. And I spoke to directors about nominating both male and female attorneys for this, and it was their choice to do that. When I looked at this position, it was important to me to try to get someone that checked all the boxes. I agree with you that I think Judge Ruth Bader Ginsburg said anywhere decisions are being made, women should be there, and I agree with that. In this incident, they were considered. Our choice was to go with Mr. Roberson, again, because of looking at all the demographics, practice size, solo practitioner, where he was located, size of the firm. It's hard to hit every demographic with every single nominee, Yolanda, but I do agree with you and I hear you. And my hope is the next time that we have a nomination for this, if not the chair and the president, other directors also nominate female attorneys to be considered. But I do agree with you and I understand. I hope that answers your question.
Thank you. I hope that is the case in the future and there are women considered. Thank you.
Thank you, ma'am. Director Baruch.
Thank you, Mr. Chair. Can you hear me?
Yes, sir, we can.
Okay, great. It seems to me we have three great candidates here and probably can't make a mistake with any of them. I practice in front of the commission fairly often. I represent judges there, and so I'm familiar with its work and have some unique concerns because of my work there, and want to just spend 60 seconds telling you why I would support Ernie Aliseda for this. It's been my privilege over the past 15 years to work repeatedly with Ernie in various bar roles. When I was chair of the Bar College, he was on our board. I worked with him in connection with my first term on this board. And the two words that come to mind for me with Ernie are civility and judgment. I counted on him repeatedly over the years because of his exceptional judgment. And I'm talking about sound, measured, mature judgment. The second is civility. In the 15 or 20 years that I have known Ernie, I honestly don't know that I have ever heard him say an unkind word to or about anyone. And it seems to me in this particular environment, at this particular time, and given what's gone on at the commission over the past 12 to 18 months, that the qualities of civility and sound judgment would be exceptionally helpful at the commission. And that's why I would urge everyone to support Ernie. Thank you, Mr. Chair.
Thank you, Director Brugge. Director Flores, Media Past President, TYLA. Mr. Flores, the floor is yours.
Thank you, Mr. Chair. I want to start off by tying this into the three resolution recipients that President Larry McDougall honored today, three of which served in the United States military. Some were trial attorneys and some were judges, but I believe their military service fortified the key principles of leadership, fairness, accountability, and ethics. And I don't say that because of my own personal experiences in the United States Marine Corps. I say that because I believe, along with Martin Luther King, that the true measure of a person is not reflected where you stand in times of comfort, but where you stand in times of trial and controversy. And I think that's what made those individuals special. Having developed those experiences, having developed and experienced the impacts of war and combat, I can attest that those experiences cement into one's soul and spirit the unwavering adherence to honor, courage, and commitment. And that's why I think Ernie Aliseda especially is made to serve as our appointee on the Commission of Judicial Conduct. You've heard he's a retired lieutenant colonel, judge for the U.S. Army, has served overseas in multiple deployments in service to his country. He's one of the state's most well-regarded and experienced trial attorneys. Currently, he serves as the general counsel for one of the larger hospitals south of San Antonio, DHR. Luis has covered that very well, his experiences as a judge. A lot of you have heard of his experience as a judge, but we haven't listened and really grasped his experience as a trial attorney. Similar to Mr. Robertson, having practiced a full array of areas of practice for about 28 years. Before DHR, he was a lawyer for the firm of Dykema
Mr.
Cox
Flores,
Smith,
please finish your thought.
with Fred Lloyd Insurance, covering cases in Texas, New York, New Mexico, across the state. I want to encourage this board to not just recommend anybody, but just recommend our very best. Our very best. And I believe Ernie Aliseda is that candidate. Thank you.
Thank you, Mr. Flores. Ms. Deborah Cordova, are you with us? Director Cordova.
I am. Thank you, Mr. Chair. I echo everything that everyone that has said on behalf of Judge Ernie Aliseda. I do want to add a few brief words. I've had the opportunity of working alongside with Judge Ernie Aliseda here in the Rio Grande Valley community, and he has a stellar reputation. Not only does he also have judicial experience, but his credentials that Luis Cardenas mentioned and David Calvillo and everyone else exemplify that he is the best and most qualified candidate for this position. He's honest, he's committed, he's dedicated, and he's ethical, and has been in every position that he has held and continues to hold. So I highly encourage the board to vote for Judge Ernie Aliseda. Thank you, Mr. Chair.
All right, I'm seeing, okay, Director Tolchin.
Just a brief comment. The
concept of appointing someone to this commission who represents attorneys, as it might be seen by third parties, is something that we should take to heart very seriously. If you are appointing people for disciplinary panel, which many of our directors have to do, for a public member, if I'm not mistaken, we're told that the spouse cannot be an attorney. By the same token, when we tell our members that we've appointed someone to represent attorneys and we refer to them as honorable so-and-so, and to the Judicial Commission, there is the appearance that we've put a judge in and not an attorney. Those are all my comments, just the form of it. Thank you.
Thank you, Director Tolchin. I'm seeing no other hands regarding discussion about the candidates. Before we vote, Director Fisher, I'm going to let you have a few minutes to respond. I'm not going to limit you to the 2 minutes. I'm going to give you 4 minutes, but I would ask that the content does not become abusive in any way. That said, I will give you 4 minutes to speak. At the end of that 4 minutes, though, that will be your time. So your time to speak starts now. Thank you. Steve, you're muted, but I'll give you your second. There.
I want to answer some of the questions about demographics. Yolanda said that there's not many, there's only 2 women on there now. She's correct, but there were about 5 just a few months ago. The governor removed 2. One of them, the former chair, resigned, and then Lee Gabriel of Justice left before her term. So it wasn't intentional. We had a really big representation of women. As far as Spanish-speaking attorney members on there, I was only the second one since the group's inception in 1965. And the first one was in 2007 from Corpus. I think, you know, without taking sides, because Dave Klein may speak Spanish perfectly, I don't know. And I don't know about the other one. It is helpful to have someone who speaks and understands Spanish, because I've found things from the hearings, you know, where it'd be good to have someone who could really accurately translate. So I would just say that I don't think there's been one from the Valley, but there was one from Alice, and he also had an office in Corpus. So those places have been underrepresented. You know, I echo what Lucy says, and I realize we don't have time for questions, but you guys should know that when I first said, you know, in January or whatever, that I was going to look for someone, a lot of people called and they asked about what goes on in the committee and how much work, and I was warned that there was a lot of acrimony even before I started. And so a lot of them, good people, the appellate judge in El Paso, went and did some research, and all but one called back and said, you know, I don't think I want to be on this. So it's great to have 3 people with good resumes, but there's some other character issues and that you need. And I frankly just wasn't good at my job. I couldn't decide who was telling the truth. I'm not a great judge of character. And I set a record for recusal. So you don't really want someone who knows all the judges and many of the lawyers in the state, because on some of the most important cases, I had to recuse myself. So look at those considerations. You know, one other thing that may come up, a lot of different bar associations asked me to do a CLE. The rules, which they said they were going to change, says only the chair and the executive director could speak to the public. So I get permission. They say you're forbidden to do it, and I did it anyway. I believe I listed the cases and they never refuted them. But that's something that might come up. How would your candidate do if he's asked to give a CLE? The law is clear, and one of the other reasons that I'm not going to be there is we would have filed a suit the Friday after the last meeting, and my volunteer lawyer was in the hospital. So think about, you know, some of these other qualities that aren't resume qualities. My understanding is that all 3 candidates are good. It does help to have a Spanish speaker on there, in my opinion. There's one other member on there now who speaks Spanish. And that's all. I don't need my 4 minutes. Good luck. I enjoyed the privilege of serving, and I hope we find somebody that's really good.
Thank you, Director Fisher. Okay, so let's talk about the election. We'll be using the Board Effect platform tool called Poll for the online voting. Don't worry, when I get through reading this, Chelsea and Jennifer are going to take over, and they're going to make it to where we can all get to the right place. So bear with me. We'll be using the Board Effect platform tool called Poll. It's imperative that you log into Board Effect. If you're having difficulty, please call or text Chelsea or Jennifer. You can see their numbers on the screen here in just a few minutes. The State Bar rules require that directors be present to vote. Voting by proxy is not allowed. Only voting members of the board may vote for the appointee to the State Commission on Judicial Conduct. These electronic votes are subject to both the Open Meetings Act and the Open Records Act. For that reason, we're having you log into your Board Effect account as verification. In the first round, you will vote for one of the three candidates. If one candidate receives a majority vote of the board, that candidate wins the election and will be the appointee to the State Conduct on Judicial Commission. I'm sorry, the State Commission on Judicial Conduct. If no candidate receives a majority of the board members present and voting, the candidate receiving the votes will be dropped from the poll and we'll have a second poll with the remaining two candidates. If one of the two candidates receives a majority vote, that candidate wins the election. In the case of a tie, the chair may cast a vote to break the tie. I am abstaining from the original vote for that reason. Somebody asked me earlier why I gave the chair to Jerry earlier. It's because my opinion is such that the chair should be neutral in these actions. So I took a position on it, that's why I gave it to Jerry. I've had that 3 questions on it, so I figured I'd just tell everybody. But I am abstaining. At this point, Chelsea and Jennifer are going to provide instructions on how to vote using Board Effect. You need to be logged in. If you have any questions or help, contact Chelsea or Jennifer. Everybody sit tight. We're going to get you there.
Okay, this is Jennifer. Chelsea's getting ready to start sharing her screen. When she takes over the screen, please exit the full screen so you can see your own Board Effect page. Chelsea is sharing her screen to demonstrate on how to locate the polls on Board Effect. On your own computer or device, please make sure you are logged into your board portal. If you're on an Android tablet and must log into Board Effect in the browser. Any issues, please call myself or Chelsea. Our numbers are on the landing page of Board Effect, and we can help. Round 1, from your computer, please click on the State Bar logo located at the top left corner. This will open another tab and you will be on your Board Effect homepage. Scroll down to see My Polls. Click on the name of the poll, which is number 1, electric ballot for appointment to the State Commission on Judicial Conduct. Click on the link. Please make your selection and hit submit. Your vote is complete.
Okay.
Can you tell us how to fasten our seatbelts as well?
You leave Jennifer and Chelsea alone. They're making this very easy on me today, Randy. I don't need this from you right now.
That was great. That was excellent.
Okay, we're getting there. A few directors that still haven't voted. If you are having an issue voting, contact us. You can call me too. But Benny Augusto, Steve Vischer, please check your email. James Wester, Michael Hurst, and I know Dr. Ferrier's on the phone with somebody now. So she's good. Okay, so Benny Augusto, James Wester, August Harris, we still need you to vote. Steve Fisher, please check your email.
Charlie, I voted.
Did you hit submit?
Yep, it says completed.
Okay, let me check. They may have just gotten it. 1 second. Apparently I said Michael Harris and I meant Michael Hurst. Sorry, Mr. Hurst.
That's fine, but you got mine, I assume, right?
Oh, let me check.
I admit I'm a bit of a Luddite, but I do follow instructions pretty well.
August, you're good. Michael, you're good. Benny, I know is getting help. Steve, have you checked your email?
Because of the internet going down, I can't even log in. But
Okay,
I'll
hold
just
on.
leave
We'll
it
get to you.
abstain.
Go ahead and mute yourself and we'll get to you. 1 second.
Okay.
Okay, we have a nomination result. There will not be a runoff. The new appointee to the Judicial Conduct Commission will be Clifton Roberson. It is 12:07. We can do one of two things. We can go through the remainder of the president's report, but that's going to include a closed session. My suggestion is we take a lunch break now and then come back and continue with the president's report. Larry, are you okay with that?
I've got Kenda Culpepper on hold, but I'll call her and ask her to call back at about 12:30.
Do you want to take her now? We just get that portion of it out of the way, or do you want to do all that at the same time?
We can do it now.
Let's take that one portion of it, and then we'll call a break after that. Okay.
Very good.
All right. The floor is yours.
I've been a trial lawyer long enough that I never want to start anything during the lunch hour. So I'm happy to wait.
Miss District Attorney Culpepper, you're good. I'm certainly not going to ask you to wait. So you're right around the corner from me. We're going to go for you right now. Floor is yours and Larry's. Thank you very much.
Thank you, Mr. Chair. At this time, I'm going to go to item number C on my agenda. It's the update on the Presidential Task Force on Criminal Court Proceedings. In June of this year, the board approved my request to form a 17-member Presidential Task Force on Criminal Court Proceedings to support the judiciary's plan to resume operations in light of COVID-19. What I did was basically selected a prosecutor, which is Ms. Culpepper, a judge, which was Judge Charles, who's also an administrative judge, and the president, Grant Schreiner, of the Texas Criminal Defense Lawyers Association. I asked each one of them to select 4 additional members from within their membership, and I appointed Judge Richardson from the Court of Criminal Appeals and myself to the committee. I'm pleased to report the task force has released a set of recommendations that have been well received by the Supreme Court and the Office of Court Administration. In fact, the OCA's recent recommendations to the court regarding jury proceedings reflect many, if not most, of the task force recommendations. At this time, I am going to ask Rockwall County District Attorney Kenda Culpepper, who is one of the 3 co-chairs on the task force, to please give us a report on the work of the task force.
Thank you very much, President McDougall, Chairman Ginn. I appreciate very much the opportunity to come before you. I see and have been watching for the last 3 hours. I see so many of my friends on this Zoom meeting, and I can't tell you how honored I am to appear before you and speak on behalf of the task force. And I just want to tell a little bit about how this idea got started. President McDougall is not paying himself enough honor by the ideas that came out of this. This idea was born from a relationship that Larry McDougall, Grant Schreiner, and I have had. We've known each other for a long time. We've been friends for many years. And this spring, we were talking on the phone about collaborative opportunities since Larry was the incoming president of the state bar, Grant was the incoming president of the Texas Criminal Defense Lawyers Association, and I had been elected and had already started serving as the president of the Texas District and County Attorneys Association. So as the state bar, the Criminal Defense Lawyers Association, and the Prosecutors Association, we knew that we had a perfect storm opportunity to collaborate as criminal practitioners on issues that could truly affect our entire profession. And so we found that opportunity in the COVID crisis. We had all been chosen to serve on an OCA task force about the resumption of jury trials. And that task force included lawyers from all practice areas. In fact, I see a number of you on here today. And during those task force meetings, I can tell you that the criminal law practitioners became really concerned about the direction of conversation that the conversation was taking regarding virtual criminal trials or virtual trials in general. We felt really strongly that virtual criminal trials were likely to be reversed because of Sixth Amendment issues, let alone the equal access to technology issues and the connectivity issues that we've heard about so much. And we really knew that or felt like our concern would be shared by criminal lawyers and judges from all across the state. The next day, Larry called Grant and I, and the Presidential Task Force on Criminal Jury Proceedings was born. He said, I'm going to create a presidential task force, and he did. Together, we chose some of the best and brightest prosecutors, defense lawyers, and judges to serve on that presidential task force. We knew that if we could get this group of leaders to agree on best practices for restarting criminal jury trials, other criminal law practitioners across the state would be more likely to follow. Grant and I agreed to be co-chairs, and Judge Charles, as you've already heard from Longview, and the regional presiding judge in East Texas, and y'all know him because he's been a former chair of the judicial section of the state bar, joined us. And you have a list of your task force members, so I won't go into that. Although I have heard that there's 1,000 pages in your pamphlet, so I'm not sure if all of y'all got to see it, but I would encourage you to look at the number or who the members were on that task force. We were awfully proud that they all agreed to join us. We were also joined during most meetings by President McDougal, Trey Apfel, Texas Court of Criminal Appeals Judge Burt Richardson, and David Slayton from the Office of Court Administration. Now, this board approved the task force on June 24th, and we started right away. 5 days later, we had our first Zoom meeting on June 29th. And as you might expect, it took a little bit of time for us to trust the process. Judges, prosecutors, and defense lawyers coming to agreement about jury trials, quite frankly, coming to agreement about anything. There was definitely tension, especially in those first meetings. Defense lawyers weren't about to waive objections to moving forward, as I think that you can guess. Sometimes it is in their best interest to delay trial for as long as possible. That's a trial strategy, quite frankly. Judges wanted to start trials as quickly as possible the next day, and prosecutors just didn't want our cases reversed. And right about that time, we had multiple offices across the state closed down because of COVID. But things settled down, and we started making amazing progress. We met for 9 weeks, and on August 25th, we submitted 14 broad interim recommendations to the Texas Supreme Court, the Court of Criminal Appeals, and the Office of Court Administration. And I can tell you that an inordinate amount of time went into each and every one of these recommendations. By the time we were finished, the document as a whole was adopted by the task force. We talked to all of our liaisons, made sure that they understood that these are interim recommendations that we would be taking to the board. But given the fact that a board meeting wasn't coming up yet, we did submit those to the Texas Supreme Court. And I can tell you that there were individual things that individual members didn't love, but I was proud that we really came together as a task force to approve the document as a whole. And I was so glad that Justice Learman, you heard her talking about the court order, the Texas Supreme Court emergency order, and that it references that OCA guidance. But I want you to know that so much of that came from our task force. And I'm just going to quickly go over the recommendations that were made because, of course, we are a representation of you from the State Bar Board and the State Bar in general. But so I'll just go through these quickly, and I'm going to summarize them since you have them in front of you, or at least in your 1,000-page packet. So obviously, we didn't want trials to proceed unless the constitutional rights of the accused are adequately protected. Number two, we are the ones that really talked about the mandatory process that needed to be created to require judges to conference and get approval from the regional presiding judges and the Office of Court Administration. And I can tell you that when we were creating when we were dealing with the task force, and even when we were meeting, we did not contemplate that we were about to create rules for not only criminal trials, but for civil trials, every kind of trial. We're proud that that has become the effect of this, but that mandatory process, we talked a lot. So we required that a mandatory process be had so that judges had to get approval by their regional presiding judges. We also wanted a full and fair record to be made to the trial court and parties to be allowed to object to the proceedings in general, meaning that if there was a concern about COVID or a concern about the safety proceedings moving forward, we wanted parties to be able to make a full and fair record to the trial court judge. Judges, we wanted them to create protocols to ensure that no court participants had tested positive within 30 days. Now, you'd think that this would be obvious, but we were hearing cases already about Brazos County where they tried 2 cases at one time. The defendants were shackled together, and they were trying all these. The jail forgot to tell the court participants, including the judge, that one of the participants had tested positive for COVID. In fact, the jail had also forgotten to tell the defendant that he had tested positive for COVID. So unfortunately, the guy that was shackled to him tested positive, and other members in that courtroom tested positive. So we felt like we needed actual language saying, you got to ask these questions. All persons entering the common areas of the courtroom must wear a face covering. And this is whether it's in a courthouse or in an arena or in the rodeo arena, wherever they're trying that case. All court participants, including the judge, attorneys, venire members, jurors, and witnesses, have to wear both face shields and masks. When speaking, then we need them to lower that mask. Obviously, you understand it's not just from a criminal perspective, but you cannot try a case. Those of you who are trial lawyers, you can't try a case unless you can see the person's face. You can't gauge their credibility unless you can see that person's face. So not only was it an issue for criminal cases, which would affect our Sixth Amendment issues, but it's also obviously in the civil realm as well. We created protocols for dealing with evidence. Lots of touching going on. We wanted a lot of that to be done digitally, but saving the opportunity for people to be able to touch evidence. Beginning and voir dire, we made the recommendation, and it was followed, that no portion of a criminal jury trial can be conducted by video conference. Now, they made the exception that if both parties agree, the prosecution and the defense, then they can move forward. That's going to take a lot of waivers. There is an exception. We made the exception with the consent of parties that a judge could allow a witness to testify by a video conference. We encourage the broad use of jury questionnaires. And then the practitioner should have an unobstructed view of venire members and witnesses' faces, and that presiding judges should be empowered to ensure compliance, because as much I really love judges, but as much as I love them, we were aware that there might be some judges in the world that might say, it's my courtroom, I'm going to do what I want to do. And so we wanted to be able to ensure that compliance. So those recommendations were adopted by the OCA. If you go back and you look at the OCA compliance document, many of our recommendations were accepted verbatim. And we are very proud of that. David Slayton was very engaged in our committee, and we were proud to have his help and to be able to help him in making recommendations. And then the Texas Supreme Court last week came out, has said that they have those orders. Much of what we recommended is in their order, but they also refer to the OCA guidance. So we met again last Monday to get an update from David Slayton about after the Texas Supreme Court released that 26th emergency order. We are now taking a break to see how jury trials are going to proceed in the month of October. I can tell you that across the state, judges are beginning that process to resume jury trials. And so we're going to take a break, and at the end of October, Monday, October 26th, we're going to come back together as this group of prosecutors, defense lawyers, and judges to make a decision on how to proceed at that point. President McDougal has given us the flexibility to extend the tenure of our committee as long as we need to meet, and I appreciate that very much. I'm proud of the progress that the task force has made. I'm enthusiastic about the work that we've done, and I'm excited that prosecutors, defense lawyers, and judges have been able to come together to make really valuable contributions. So with that, I'll answer any questions, but President McDougal, Chairman Ginn, thank you so much for giving me the opportunity to update you on the task force.
Thank you, District Attorney Culpepper, and for your work on this. And as we go through these uncertain times, which you and your task force have done, we appreciate it. So this is Larry's task force. He will need to make the motion for approval of the creation of the task force. Is there a second?
A second.
All right, it's so seconded by Ms. Cortez Maras. Is there any discussion?
Charlie, I believe this task force, this one's already been approved. back in the June.
Yeah, it was approved on June 24th.
Hold on, Larry, 1 second. I'm sorry, 1 second. Wrong portion.
Well, that would be embarrassing if we did all this work and y'all hadn't even approved us, so.
Okay, all right, I guess we're just thanking you for the report. Thank you very much. I had wrong pages I was looking at. Okay, so I told you all that we were going to lunch. We need to actually go into the quick 11D and then closed session. It should not be the closed sessions of the past. But we do have some reasons for that. Larry, President McDougal, if you would talk about 11D, and then we will go straight into closed session, and then we will take a break for lunch right after the closed session. Mr. McDougal, the floor is yours.
Thank you, Mr. Chair. 11D is an update on the potential purchase of real property at 1415 Lavaca Street, and this is going to be discussed more in closed session. Just as an information though, in late 2019, the State Bar began exploring the possibility of purchasing the historic building immediately to the west of the Texas Law Center, which is located at 1415 Lavaca Street for the benefit of the bar's operation and our membership. This was to be used as office space and meeting space. In January 2020, the board approved the purchase and another offer was made and accepted by the seller, so we didn't get it. Until recently, the property was under contract by the developer who was seeking to build a hotel tower. That project did not come to fruition, and we are again considering a purchase of that building. We will now discuss the possibility in closed session as permitted by the Texas Open Meetings Act.
Okay, directors, you don't have to do anything. We will move you into closed session right now. So just sit tight at your computers and we'll go directly into closed session. It is 12:23 p.m. Go ahead, Jennifer.
Someone try now.
Try it now. What about now? You can hear me?
Yep.
Okay. All right, we are back. It is 1:39 p.m. At 12:23 p.m., the State Bar Directors recessed the open meeting and reconvened in closed session pursuant to Texas Government Code Section 551.071 for the purpose of consulting with legal counsel to include discussion regarding all pending or contemplated litigation, including regarding McDonald et al. Sorrells at the Fifth Circuit, Samantha Carter in the Northern District, and Law HQ versus Willing in the Western District, Section 551.072 to deliberate regarding the potential purchase of real property at 1415 Lavaca Street in Austin, and Section 551.074 to deliberate regarding personnel matters. So at this point, we'll return to the action item 11D. President McDougal, you have the floor.
Thank you, Mr. Chair. Mr. Chair, based upon deliberations in our executive session, I move that the board approve the purchase by the State Bar for real property at 1415 Lavaca Street in Austin, Texas for a purchase price still under negotiation as discussed in closed session, and authorize the ad hoc subcommittee to incur due diligence expenses as discussed.
And as a friendly amendment to that, are you including and according to terms discussed, Mr. McDougal?
Yes, sir.
Okay. We have a motion. Do we have a second?
Second.
All right. I think Adam Schrammick was our second. Any discussion? Hearing none, all directors in favor, please vote by saying aye.
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 Any opposed? Hearing none, the motion passes. We will take a break now for.
Mr. Chair, I have a second motion.
Oh, I apologize, President McDougal. Go ahead.
I also move that the board delegate to the executive director the authority to seek an amendment to the current year's budget from the Supreme Court in order to complete the purchase of 1415 Lavaca Street.
I second.
Director Smith seconds. All those in favor, please respond by saying aye.
Aye.
Any nays? Hearing none, the motion passes. All right, it is now 1:41. Why don't we take a 20-minute lunch break? Why don't we report back at 2 o'clock for our meeting? Mute yourselves. Please do not shut your computer off. We'll see you back at 2 o'clock for a lunch after lunch. Thank you. All right, welcome back. It is 2:02 and we're going to call the meeting back to order. If directors can return to their screens, we appreciate everyone's patience letting us have a quick break there for lunch. Before we continue with the President's report regarding one clarification regarding the Judicial Conduct Commission and the term for Mr. Roberson, that will begin on November the 20th of 2020. So Mr. Roberson's term will begin on November 20th of 2020. Mr. McDougall, we were in the middle of your report. We have concluded, I think, with item number D. We will give you the floor for the rest of your report, sir.
Thank you, Mr. Chair. I'd like to move on to action item number E. This is to consider and discuss the approval of the creation of a task force on public protection, grievance review, and client security fund, and approval of its roster. Today, I'm asking the board to approve the creation of a presidential task force on public protection, grievance review, and client security fund. This has been included in your meeting materials with a roster and a mission statement and a fiscal impact report. This task force will study the grievance process in the Office of Chief Disciplinary Counsel with the mindset of ensuring our process is fair to the lawyers of Texas, while at the same time ensuring that the public is protected from lawyers who may take advantage of them. At the end of the process, the task force will make recommendations to the board of directors regarding any changes in procedures and rules the task force believes are necessary to protect the attorneys of Texas and the public which these attorneys serve. The task force will also study the client security fund to determine ways it can better serve the public while considering the limited resources that we have available to it. The task force consists of 21 members from across the state. They will meet by video conference, so the fiscal impact should be very minimal. I also like to add that I have chosen Judge Mike Fields, an African-American male, a former judge out of Harris County, to basically chair this task force. When I tasked him with this, I asked him to give me one of the most diverse task forces that we can come up with, both on the issues of geographic area, practice areas, race, and sex, and ask him to put this together. And I believe that Judge Fields has actually put us together a very good one. We've also added 3 board members, which is Steve Naylor, Lucy Forbes, and Sherry Goldsberry. And so I think we have an excellent task force put together. The recommendations will then be brought back to our board, and then the board we can move forward from there. I move, Mr. Chair, I move that the board create the task force on public protection, grievance review, and client security fund, including the approval of its roster.
Any director who wishes to second the motion, please unmute and state your name. Don't just say second. Do we have a second?
Yolanda Cortez Maras, second.
All right, Director Yolanda Cortez Maras is our second. Is there any discussion? Pull up my participation tab real quick. Seeing no hands, hearing nothing. All those in favor, please say aye.
Aye. Aye.
Any opposed? Hearing none, the motion passes unanimously. Mr. McDougall, the floor is yours.
Thank you, Mr. Chair. I'll move to action item number F. Consider and discuss approval of the creation of the Courthouse Access Badge Work Group and approval of its roster. In 2018, President-elect Randy Sorrells created a Courthouse Access Badge Task Force to study the possible implementation of courthouse access badges in Texas. Today, I'm asking the board to approve a 14-member work group that will continue the efforts of the 2018 task force. The roster, mission statement, and fiscal impact report are included in your meeting materials. This work group will meet by video conference, and so the fiscal impact is expected to be minimal. I have asked David Sergi to head up this task force, and he chose exclusively on his own the 14-member task force that it consists of. Mr. Chair, at this time, I move that the board create a courthouse access badge work group, including an approval of its roster.
Any director who wishes to second the motion, please unmute and state your name.
This is Benny Augusto, I second.
All right, Director Benny Augusto seconds. Any discussion? Seeing no hands, hearing no discussion, all those in favor, please say aye.
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 Any opposed? Hearing none, the motion passes unanimously. Mr. President, the floor is yours.
Mr. Chair, we have another action item, which is action item G. This is going to be considered, discussed, the approval of ratification of the ad hoc submission committee's decision to grant approval of the business law section's request to file an amicus in House Canary Inc., House Canary Analytics Inc. versus Title Source Inc., the Reporters Committee from Freedom of the Press and Houston Forward Times in the Supreme Court under cause number 19-0673. Mr. Chair, last week, the board's ad hoc submission committee approved the business laws section's request for an expedited approval to file an amicus brief in the House Canary case currently before the Supreme Court. Included in your meeting materials, wait a minute, I'm sorry, going to the wrong page there.
I did it earlier. I think coming from a committee, Mr. McDougall, it needs no second. I just need your motion.
I move that the board ratify the ad hoc submission committee's decision to approve the filing of the amicus brief by the business law section.
Coming from a committee, it needs no second. Is there any discussion? Hearing none, seeing none. All those in favor, please respond by saying aye.
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 Any opposed? Hearing none, the motion passes unanimously. Mr. President, I think that takes us back up to the beginning of your report, items A and B.
Yes, sir. I believe all I have left, I think, is item B. Is not correct?
I'm sure. I didn't know if you had a general report or not. So if it's item B, I'm good with that.
Okay. As we talked about in one of the special sessions and a motion that I seconded, I have put together a basically, let me get to the front page of it here, a 3-step plan to address the issues of dealing with racial inequality and inclusion within our state bar. Inclusion, I've always believed that the best way to combat racism is by including diverse people. With all the lawyers that I have spoken to in the last 2 months, not a single person has spoken out against equal treatment for everyone, regardless of race, sex, religion, or even sexual preference. Not a single person has spoken out against it. Everyone believes that this is an important issue and one that we should address as a bar. As a president-elect, you're responsible for appointing persons to committees, the Texas Bar Foundation, and other positions within the legal community. I was very proud that I focused my appointments on practice area, geographic location, race, and sex in making my appointments. As president-elect, you're given a sheet of all those who applied and what committees and positions they applied for. Where I had qualified minorities, I appointed them into leadership positions, not just on committee positions. Yet those forms do not include a mark or indication of race. So I spent several days researching those that applied before I made my appointments. These forms need a location for those applying to place their race, sex, and even sexual identity on those forms. These will be a big help to our future leaders in making more diverse appointments. It's an easy one to fix. So what I'm asking is that when Ray Cantu sends these forms out and they do these things in this upcoming year, that they place on the applications, they put a deal in there indicating race, sex, and even sexual preference. This will make it easier for the president-elect in making these appointments to be more diverse in making those and not have to sit there and research people one at a time as I did. As president, you get to appoint with board approval one or more directors at large. In September of 2019, I may have jumped the gun, but I already announced who I wanted as my director at large when that time comes. I chose an African-American female. And I want you to understand, I didn't choose her because of her race or sex. I chose her because I found her to be an amazing person, somebody that I think would do well on our board and somebody that I want in a leadership position. I hope that she still applies for that slot. This appointment does not happen until 2021. Also, today we voted on a member of the Commission for Judicial Conduct. The chair and I both nominated an African-American male. And for me, again, this was not about race. When we had the list and we started calling people, I called Clifton. I spoke to him about the position and interviewed him about what we have and what's going on. I chose him again because of the person I found him to be. I found him to be a great person, an amazing person. And if you heard the people talk about him today, they all had the same impression that I had of Clifton Robertson. Today, earlier, I asked you to approve a President's Task Force on Public Protection Grievance and Client Security Fund. Again, I chose another African-American male to lead this task force. In fact, I asked him to put together the most diverse group he could find, and I believe that he did do that. Again, I chose him not because of his race, but I believe that Judge Michael Fields is the right person to lead this type of group. These are just a few of the people that I have appointed to different positions and leadership positions that I've been able to do. I point this out because we have outstanding people of all races and sexes, and we should not be afraid to appoint someone just because they may be different. When we close our mind, we miss a lot of good talent. With this inclusion, I'm going to personally make phone calls to minority lawyers in each director's district and encourage them to run for director this year, in this upcoming year, actually. I have no intention of discouraging anyone from running, but I would like to see a minority candidate running in each district if possible. I'm going to mention Steve Bolton. He's running for president and is a petition candidate. If you look at the petition that he has, look at the first page, you will find Leon Carter in the number 1 spot, I am in the number 2 spot, and Joe Longley in the number 3 spot. This is nothing against Sarah Laura, who's also running by nomination, but I believe Steve to be an amazing person and one of the first people I called after the June 10th incident. I also appointed an Asian American to the spot on the Bar Foundation. Again, not because she was Asian American, but I knew her to be an active in the community and a person of high moral character. I even appointed an LGBT man to a work group. And again, not because he was LGBT, just because I know the man and I know him to be an outstanding individual. And by this, in the inclusion, I want to encourage all our future leaders to be inclusive in their selections. If not, then we will always be divisive and there will always be that distrust. I believe with inclusion, we can defeat this. Step 2, implicit bias. The board of directors has voted that each director will take an implicit bias course before the end of the year. The Texas Judiciary is considering making this an annual course for all the judges in Texas. The African American Law Section has requested that implicit bias training be annual for all Texas attorneys. As president, this is not a decision that I alone can make. The board has already referred this issue to the MCLE committee for their decision. But what can I do? I've already been in discussions with our executive director, Trey Apfel, about providing a free implicit bias course for all Texas attorneys, and I intend on applying for MCLE ethics credit when we do this. Yet I do not want to stop there. I will work with the CLE committee chair, Scott Rothenberg, to put together a more advanced implicit bias training for the Texas lawyers. I cannot tell you that this will be free. Again, that is not within my power, but we want it to be available for any lawyer who wants or feels the need to attend. Now comes the big one that I'm the most proud of, and I have to give credit to this one to Rob Crane. In 2017, the Dallas Bar Association, in conjunction with Project Unity, started a Together We Dine program. In this short time, they have had over 1,000 people participate in this program. This is a listening exercise. I participated in one a few weeks ago along with several other directors and our executive director. This provides a safe place for people of all races and sexes to openly discuss racism in a way that most of us never have. I have several African-American friends that I go hunting with, I go fishing with, I play golf with, they've spent nights at my house, they've even had dinner at my dinner table at home. Yet racism was never a topic that we ever discussed. This is not my brainchild again, but I've been working with Rob Crane putting this together. So here's the plan. We are looking to do something that no other bar association has ever done. I've reached out to several bar presidents in the Southern Conference and asked them about what they're doing and how they're doing it. Our plan is to hold a minimum of 17 programs by the end of June, one in each bar district. If the demand is there, we will hold more than one in each district. Every lawyer licensed in Texas is going to receive an email invitation to attend. We will send these out by bar districts. There is no cost to the participants. Project Unity will provide the facilitators and will run each of the programs for us. The cost to the State Bar of Texas will be in staff time of sending out the invitations and setting up the Zoom meetings. This gives everyone involved a safe place to openly discuss different aspects of racism. I actually enjoyed the program that I participated in, and it opened my eyes to many different points of view. Yet I do not want this program to end at the end of my term as president in June of 2021. I want to continue this program throughout my year as past president. And hopefully this will be a successful program and the State Bar will carry it on with this project even after I'm already gone as past president. This is just not a matter of us sending out email invitations, but I intend to participate in as many of these programs as possible, if not every one. Again, this will be something that no other bar in the state or no other state bar has ever attempted. It will expose hundreds of Texas lawyers and will help build a better understanding within each other by bringing racism that much closer to an end. In closing, I am asking every lawyer in Texas to join me in this. Participate in this Together We Dine. If you didn't participate in the one that we had a few weeks ago, when we start this, get in one. I was impressed. It was a great program. And it's one that, it's not an offensive program. It's one that actually opens up a free dialogue and free thought. Let's take this negative and turn it into a positive. Help me in making the State Bar a leader in healing the wounds of racism by including everyone, regardless of race, sex, religion, sexual preference, or any other barrier that makes someone different than you. By participating in Together We Dine program and doing it more than once if space permits. By opening your mind and heart and learning that we have more in common than we do dividing us. Thank you, Mr. Chair.
All right. Is there any discussion? Seeing no hands, seeing no comments, we will move forward to the next item on the agenda, report from President-elect Sylvia Barunda Firth. Madam President-elect, the floor is yours.
Thank you, Chairman Ginn. Before I get started, I think I need to apologize to my Longhorn lawyers for my wardrobe malfunction. On this very weekend, I show up at a board meeting wearing red and black. So I apologize, and I assure you that that won't be the case tomorrow. So a little bit of levity. They've had a pretty heavy agenda today. So my report is just that. There are no action items. It's just a report. First being with regard to the Task Force on Diversity, Equity, and Inclusion, which you all approved the roster of on the September 10th meeting. That's going to be chaired by Joe Escobedo, our former board chair from McAllen. And we're right now in the process of coordinating calendars to have our first meeting. I've invited past President Martha Dickey to be with us at our first meeting, and she has graciously accepted the invitation. She led the last task force that was a state bar task force on issues mostly focused on women, but we're going to start with, we're going to let her kick us off, and we're going to see what things have been accomplished since the 2007 report, what things remain, and then that'll be our jumping off place for the work to be done. The second report I have is with regard to the Justice and Leadership Work Group. This is the work group that's being chaired by Director Carmen Rowe. And this goes back to a question that Carlos Cardenas had earlier. What about the people that came and spoke to us and gave us ideas? And do we ever close the loop and go back with them? Well, this was the commitment that the board has made to review all of the recommendations and comments that were made by the 61 people and the almost 1,000 written comments that we received at our special board meeting, to go through them and see which ones of those recommendations can be can and should be implemented by the board. So this is our follow-up to those people commenting. I've talked before a little bit about the listening session that I'm working on with former State Bar President Lisa Tatum. So this is, we've already selected a date. It's October the 7th. We think it's going to be around the noon hour, and you'll be receiving more information about this later. It's going to be open to all lawyers, and we're hoping to have really good attendance. And the panelists will discuss how systemic racism has impacted them as individuals and a member of the community, and some as bar leaders. While this is not a novel issue, they'll discuss the impact of systemic racism as it relates to the recent events in the bar. With regard to practitioners who practice law in Texas, and member engagement in the state bar activities, as well as bar activity limitations that come from Keller, Janus, and the McDonald decisions, trying to identify what the proper role for the state bar should be in this greater community discretion. And also the role and responsibility of attorneys as advocates, officers of the court and the justice system, and particularly in light of Rule 5.08 of the Texas disciplinary rules. We're hoping, we're still working on the write-up, and we're hoping that it will be eligible for CLE credit under the ethics section as well. So stand by, you'll be hearing about that very soon. So as president-elect, I chair the budget committee, and I have an update for you all. The budget committee had its first meeting on Monday, September 21st, and we discussed the state bar's current financial position, the budget process, and the timeline for the preparation of fiscal year 2021-2022. Over the past 3 years, with the leadership and direction of the immediate past President Sorrells and past President Joe Longley, the board has increased reserves by 20% or $2 million, which brought the level of minimal reserves to $3 million of operating expenditures, or a total of $11.1 million. That's a very fiscally responsible place to be. Last year, under the leadership of President-elect McDougal, the current President McDougal, the bar invested over $1.2 million in its IT infrastructure, which will be used to upgrade the law center's audiovisual equipment, provide a new information system to replace the 15-year-old case management system for the client assistance program, a client attorney assistance program, and to redesign the texasbar.com website to improve service and message delivery to the public and members. Our challenge this year is going to be to draft a budget that continues to ensure that the state bar stays strong in financial footing during this period of uncertainty, while providing the best use of our funds with which we're entrusted. The pandemic has caused some disruption to our normal operations. And during this meeting, we discussed some of the major revenues of the bar, including membership dues and Texas Bar CLEs. So we have a slide that we'd like to share with you all to show the budgeted revenue by major category of the state bar's general fund. And I think the staff is supposed to pull that up for us. Yeah, I don't know if you can see it. As board members, it's important all of us understand our key funding sources, as those sources keep the bar in a strong financial position. Membership dues account for 48% of the general fund budget revenue, while the Texas Bar CLE provides 32% of the total revenue of the state bar. The committee is paying close attention to the trends of these funding sources, since they will be key to drafting a balanced budget. Budget packets will be furnished to the state bar's divisions and department directors on October 1, with the deadline of completing them by October 16th. And once the budget data is received, the finance division will prepare and analyze the budget. The budget committee is scheduled to meet on Thursday, December 10th via a Zoom call. Division and department directors will attend that meeting to provide information with regard to their particular area of the budget. And during this meeting, the committee will finalize the proposed fiscal year 2021-22 budget for presentation to the executive committee and to the board at their respective January meetings. And that's all I have to report on today, but I stand ready to answer questions if anyone has any.
Any discussion or questions for Madam President-elect Sylvia Brenda Firth? Hearing none, seeing none, we will move to the next item of the agenda, report from our immediate past president, Mr. President Randy Sorrells. Mr. Sorrells, the floor is yours.
Thank you.
Hold on, Randy. I'm sorry. Director Fisher, I understand. I see your hand raised now. What can I do for you, Director Fisher?
I just have a comment on the CLE, and I've been even questioned on this during the break. I think the CLE department, what the bar's doing, is just great, and people don't appreciate it and demanding answers about why the CLE isn't free. If you look at it during the pandemic, if you look at that chart again, we receive about $14 million out of the $52 million. But that number has been static It's been 13, 14, 15 for years. And the bar's done such a good job about letting people, groups, Facebook groups, whatever, present free CLE. And there's more free CLE. We helped start a site about free CLE a few months ago. And there's so much available and so much of it is good. And, you know, we just can't please everyone, but that department is in my opinion, the flagship of the bar. There are a couple of things we can do. There used to be a program called sort of an all-you-can-eat, sort of a buffet, all the CLE you could take, and that cost $1,000 a year, and was discontinued because people didn't, they'd sign up and not go. That was a really good program, aside from the education, aside from showing the people how good the advanced courses are, which is what most people went for. But there was another aspect that nobody ever really talked about. When I would go to these things, there was always this big group, well, maybe 30 or 40 of these older lawyers. Some of them were retired, and it was a good place for them to get together, and they loved it. And I think the fix on that is that we still
Dr.
have.
Fisher, and I hate to interrupt you. I want to stay on task, and I want to stay with our agenda. And so I appreciate your comments about Madam President-elect's budget and the CLE, and I agree with you and join with you in thinking our CLE department is great. But I think we need to stay on task if you're okay with that.
I'm okay. I just think that program the CLE needs to get a lot more credit than it's given. And it goes.
I totally agree with you. I totally agree. Thank you, Director Fisher. Mr. President Soros, I'm sorry to interrupt you. Please, it's your floor.
No, I'll try to keep this brief. First, generally, I want to thank President McDougall for offering 3 suggestions to further the diversity and inclusion efforts of the State Bar. And those who may listen, they may say there's too much. Some may say it's not enough. I think he is still open to hearing other ideas. The Together We Dine program, which was a proven success in Dallas, thanks to Rob Crane, going statewide is a great idea. So if others have ideas, I encourage you to send them to President McDougall. I think in this discourse, we can find goodness and improvement, and I appreciate President McDougall's efforts to do that. Second, on page 709 of your packet, there is a request from Director Andrew Tolchin. And I want to turn it over to Andrew, and what we're going to do is consider the approval of his request that the MCLE committee study and report to the board regarding the possibility of categorizing CLE courses on the subject of mental health and substance abuse. It's on page 709 of your packet. And Andrew, since you made the motion and did the research, if you don't mind talking on that for a minute, I'd appreciate it.
Sure, Randy, thank you. So I did some research and I found that a number of state bars, as well as voluntary bars across our country, provide ethics or professional responsibility CLE credit for CLE presentations on mental health issues or substance abuse. And I understand that if TLAP were to apply for such a thing, they would routinely now receive that kind of credit. But those who create these courses may not know because there's apparently no written policy on this. So I wanted to let us have the opportunity to let the MCLE committee know that we care about this issue and to report back to us. So I do have a motion, and I'm hopeful that it will receive a second. I move that the board request the MCLE committee to study and report to the board by January 2021 regarding the possibility of categorizing CLE courses on the subject of mental health and substance abuse as eligible for, quote, ethics / professional responsibility, close quote, credit.
I'll second that.
A second.
Okay.
I think Charlie, you have to take over from here on Andrew's motion, and I certainly support the motion as well. If you're on, you may be on mute.
Sorry, I was talking, but I did not have myself on the right volume there. Diane St. Ives is our second. Is there any discussion? Hearing none, seeing none. All those in favor, please respond by saying aye.
Aye.
Any opposed? Hearing none, the motion passes unanimously. Mr. Sorrells, the floor is yours.
And that concludes my report. Thank you so much.
Thank you, President Sorrells. We're going to take an action item out of order, excuse me, an agenda item out of order. Judge Yeary, are you on the call?
I am. Can you hear me?
We can. The floor is yours, sir.
Super. Thank you. I just want to thank you for the opportunity to address you on behalf of the Court of Criminal Appeals. We at the Court of Criminal Appeals are happy to be able to cooperate when we can with the board as it conducts its important work for the State Bar of Texas. And we appreciate the open line of communication that we enjoy with you on matters important to the administration of justice in our state. I'm especially honored to report that only 3 days ago, September 22nd of 2020, the Court of Criminal Appeals marked its 129th anniversary as the court of last resort for all criminal cases in our state. You might remember that we celebrated our 125th anniversary back in 2016. As Texans, we know we're all trailblazers by nature, but we're honored at the Court of Criminal Appeals to continue to play our unique role in our Texas Judicial Department of Government. I want to thank Justice Lehrman for her earlier report from the Texas Supreme Court. I would like to just adopt so much of what she said. As Justice Lehrman reported, we've had quite a year in 2020. We've had to adjust to new safety precautions due to the COVID-19 pandemic. And this caused all of us to begin working from home and to begin utilizing online tools like this Zoom platform to conduct our conferences and to host oral arguments from litigants in our court. Like many other courts throughout the state, with the help of the Office of Court Administration and its director, David Slayton, we've made that adjustment almost seamlessly. While most of us have occasionally been back to the Supreme Court building since the start of the pandemic, we continue to conference and hear arguments online, with arguments being broadcast live on our YouTube channel. We in the Texas Appellate Courts also suffered through a well-documented ransomware attack this year. That event compounded the difficulties encountered due to the pandemic because it made accessing certain court records remotely exceedingly difficult. But again, with the incredible assistance of the Office of Court Administration, we've come through that terrible event as well. As Justice Lehrman reported, our Texas Supreme Court has issued during this COVID-19 pandemic a number of emergency orders to ensure the integrity and responsiveness of our system of justice. When appropriate, the Court of Criminal Appeals has joined with and signed off on those orders as well, and we continue to keep our eyes on the horizon for issues on which our guidance can be helpful. The Court of Criminal Appeals is also privileged to administer the Judicial and Court Personnel Training Fund, which we sometimes refer to as the grant. Through the grant, the court oversees distribution of funds appropriated by our legislature for the continuing education of judges, other employees of the Judicial Department, prosecutors, defense attorneys, and others on matters relevant to the performance of their roles. And this includes on matters such as the use of scientific evidence and issues related to mental health. We're working with the clients that currently are served by the grant to also adjust to this new reality where remote learning is becoming preeminent. Our collective attention to issues relating to mental health has also increased immensely in recent years, and that's so important, especially in our system of criminal justice. I will take this opportunity to report that our court has made a mental health resource guide available on our Court of Criminal Appeals website. It contains information about a number of agencies and offices that provide resources and services related to mental health in our state, including the identification of specific organizations providing services in specific counties. I encourage anyone with an interest in locating providers of mental health services and resources to visit the Court of Criminal Appeals website and have access to that resource guide. Finally, I will report that we also have had for some years now a very active Rules Advisory Committee on the court under the leadership of Judge David Newell, and with the participation of several of our other judges as well, including myself and other members of the bench and bar. The Rules Advisory Committee considers important ways to improve the rules that guide practice in our courts throughout the state in criminal proceedings. If anyone would like to reach out to the Rules Committee or to make comments about proposed rules, an email address for that purpose is available on our website under a link for the Rules Advisory Committee. I want to thank the board for the opportunity to address you today and for the continued and open lines of communication we at the Court of Criminal Appeals continue to enjoy with you. And that concludes my report.
Thank you, Your Honor. We appreciate the time and your report and your leadership. We're going to go to agenda item number 14, the Commission for Lawyer Discipline and the Chief Disciplinary Counsel, Gina Bunn and Shauna Willing. I understand Ms. Bunn is not with us today, but I understand that Shauna Willing is going to give her report. Shauna, are you with us?
I am. Thank you. Shauna Willing, Chief Disciplinary Counsel. Gina Bunn apologizes. She was planning on being here to make the report, but she had a mediation that ran long and then a appellate emergency on one of her cases. Just quickly going through our report for this board meeting to give you just some updates on how we've been responding to the COVID-19 pandemic, now almost 7 months in. Everything's happening by Zoom. We had 2 new commission members start in our commission meeting yesterday, all by Zoom. We welcomed attorney Sally Pretorius and our public member JD Villa to their orientation. They were sworn in by Justice Blacklock on Wednesday afternoon and had their first meeting yesterday by Zoom. And just hit the ground running. They were prepared and great additions to our membership. Our investigatory hearings continue to be conducted by Zoom. Our evidentiary trials are now being conducted by Zoom as a result of the Supreme Court's 18th emergency order. And we do have some district court trials and appeals that are proceeding based on where the courts are able to conduct proceedings remotely in accordance with the OCA protocols. Summary disposition panels have always been by telephone. They're still meeting remotely. I think they may be using Zoom as well in some instances. We are fully operational and have been since mid-March when everything, we were all sent home. And again, just full credit to the State Bar's IT department for getting all the equipment and all of the things that we needed to make that happen. Our grievance symposium was ready to go in May and that had to be postponed. It continues to be on hold since we can't meet in person. We are looking at maybe changing the format to a virtual format. And so we're going to work with the MCLE department on that and maybe get something up and going spring or summer of 2021. Our annual report for the last bar year, 2019-2020 is out and a copy is in your materials and will be on the State Bar website. Contact me if you have any questions. And then finally, in your report, in the materials, you'll see the disciplinary statistics for the first quarter of 2020-2021 bar year, which ended August 31st. We had 66 complaints that were resolved through 56 sanctions, including 3 disbarments, 2 resignations in lieu of discipline, 11 suspensions, 14 private reprimands, and 26 referrals to our grievance referral program. And we were able to collect close to $54,000 in attorney's fees revenue through the end of August. And that sums up the report from the Commission and the CDC.
Thank you so much, Shauna, for being here and for your report. At this time, we'll go to agenda item number 15, the Executive Committee. We'll start with subpoint A, nominations and elections, and I'll call on immediate past President Randy Sorrells and immediate past Chair Jerry Alexander to bring us that report, and then the discussion and approval of the candidates, and after that, we will take the candidates that will be introduced in their discussion. Jerry, Randy, the floor is y'all's.
Thank you, Mr. Chair. The Nominations and Collections Subcommittee began its work in June on the nominations process. We published in the Texas Bar Journal online and notice to all committees, sections, and local bars. We reached out to the candidates in the large county large counties, Bexar, Dallas, Harris, Tarrant, and Travis, since this is a large county year. And we wound up having 9 highly qualified candidates who expressed an interest and did all the procedural things necessary to become interviewees by the committee. After much deliberation, the committee voted to select Sarah Dysart of San Antonio and Laura Gibson of Houston. Their bios and interest letters are included in the board packet under the Nominations Committee tab. These are 2 very, very wonderful candidates and very, very experienced state bar former officers and directors. And we know that they will run great campaigns. Because of the pandemic, both of them have agreed not to conduct in-person campaigning for the time being. Everyone wants to keep them safe, and also members of the bar that they would be contacting as well. This will be revisited as time progresses, and we'll work with both candidates about in-person meetings. After much discussion, the committee also decided to continue for the next year, at least, using both paper ballots and electronic voting for this year for the April election. And that goes for the presidential candidates and for the board candidates. We've done that for the past 15 years. And we may want to revisit the issue about next year's election, depending on the circumstances of the pandemic. So, Mr. Chair, at this time, on behalf of the Nominations and Elections Subcommittee, I move that the board approve Sarah Dysart of San Antonio and Laura Gibson of Houston as the state bar candidates for president-elect for the 2021 election.
Coming from a committee, no second is needed. Is there any discussion? All right, all those in favor, please say aye.
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 Any opposed? All right, motion carries. These are our candidates for the next year, president-elect. Mr. Sorrells, do you have anything to report before we turn over to the introductions?
Yeah, I think I think I do. Although I'm not sure I'm out of order. I want to talk about electronic signatures. Do you want me to wait until after the introduction?
Let's turn it over to them, and then we'll come back. That works for me. Okay. With that, then I would invite Director Santos Vargas, to introduce candidate Sarah Dysart. Santos, the floor is yours.
Thank you, Mr. Chair. And good afternoon, everyone. I have the honor of introducing my friend and colleague, Sarah Dysart. I've known Sarah for well over 10 years. During that time, I've seen the tireless effort she's put into supporting our bar and the selfless manner in which she's given her time to help so many lawyers and so many organizations. She personifies the philosophy of servant leadership. The attorneys in Bexar County and all over the state of Texas respect Sarah and recognize her as an outstanding real estate attorney and contributor to our bar and our community. Please meet Sarah Dysart, candidate for President-elect, State Bar of Texas.
Ms. Dysart, if you're with us.
I am. Thank you, Santos. Thank you, Board of Directors. Thank you, Nominating Committee, for calling me back and giving me this opportunity. I want to congratulate Laura Gibson for also having this opportunity, and I look forward to traveling this journey with her. I am a commercial real estate attorney. I represent clients throughout the state of Texas. How does a sole practitioner from San Antonio get this opportunity? My answer is hard work, providing the highest quality of legal service, and at a fair price. But there's another factor that I believe is equally as important, and that is people have to know I'm a real estate attorney. How does that happen? I contribute that to the State Bar of Texas. My opportunity to give CLE presentations, to be an active member of REPTOL, and to serve on the Real Estate Forums Committee, which I currently chair, has garnered the respect of my colleagues, has allowed me to make friends with attorneys throughout Texas, and has also given me some client referrals. So as State Bar President, I know my job will be to represent the bar on the issues of the day. I once heard Trey Apple say, you don't necessarily get the year you plan, you get the year you get. But I can tell you, as State Bar President, my #1 priority is to emphasize service to the bar and our community. I want every Texas attorney to experience getting more out of service than we give. With this challenge comes inclusion, diversity, equality, emphasis, which the State Bar is addressing so vividly today. It also requires sponsorship and recruitment. Now we're dealing with COVID. I've heard a lot about that today, and I'm very aware of the social isolation and the economic challenges that comes with that. The State Bar should continue to support TLAB. I loved Chris Ritter's presentation, but I believe there's other ways we can reach out to Texas attorneys, which we do. I really was impressed when Trey Apple talked about the law office management buffet of activities. As State Bar President, I'm thinking, so what can I bring? What can I bring forward? Now, the grievance committee and financial instability resonates with me. And as I move forward, I would like to talk about an advocacy program to help attorneys responding to grievances. Not only can we assist them, but perhaps we can even reach out to them when they fail to answer a grievance response. More to be revealed. I also think as part of benefits to Texas lawyers, we could have a financial wisdom program that would be in addition to State Bar management, that would include involving financial institutions that would make services and loans available to attorneys. But I also see a fund, not unlike the Sharon Crowley Trust that we heard about today, where we would be in a position to perhaps make grants and low interest loans to attorneys in crisis. Now, those are just ideas I've thought about. We're always thinking about ideas that should benefit Texas lawyers. I want to be part of that leadership to put State Bar resources in action for Texas attorneys. Thank you for giving me this opportunity. I look forward to continue the conversation. And I just can't tell you how much I appreciate it. Thank you.
Thank you, Sarah Dysart. We're excited to watch your campaign, and we know that you and Ms. Gibson will run successful ones. With that, I'll turn it over to Director Diane St. Ives, who will be introducing Laura Gibson. Director St. Ives.
Thank you so much. It is such an honor to introduce Laura Gibson today. The first time that I met her was at my first end of year meeting at Gulf Coast Family Law Specialist, when she was present to help introduce the winner of the award created to honor the memory of her father, David Gibson. The award is presented to someone who epitomizes and reflects her father's mentorship, generosity of spirit, and the civility he always showed to other lawyers. The fruit simply does not fall too far from the tree, as Laura's work and commitment within our profession has been equally unselfish, committed, generous, and unwavering. In her career, she has had so many opportunities to serve, and serve she did. I have read many pages of statements from others who capture Laura and her commitment to the bar, and most especially its members. A statement on Laura's service working with the Texas Minority Council program. I was amazed at her commitment, the energy and enthusiasm she brought to the task, and the large number of people who knew her and obviously respected her contributions. While serving on the TMCP, she worked on the steering committee as co-chair and then chair of the Council Award Recognition Committee, developing new and innovative ideas to improve the committee to accomplish its goals and missions. Lynn Liberato once says about Laura, she is a transformational leader, thinks big, sweats the details, brings out the best in people, and gets results. Laura founded and now chairs the Liberty and Justice for All Task Force to educate the citizens of Texas about laws that suppress minority vote, and to work toward legislative reform. Others have said, to which I concur, her commitment, her softness, and kindness are unmatched. She is a pioneer in mentorship by offering vision and guidance in a purposeful and unobtrusive manner. She possesses a true gift and ability to awaken others' inner creativity by teaching mentees how to think, not what to think, engaging, insightful, and honest. There is nothing that she cannot overcome, solve, or create, and she will involve each member of the bar in accomplishing what is best for the bar. Laura is a natural leader. She's the former president of the Houston Bar Association, former president of the Association of Women Attorneys, a former state bar director, and chair of the State Bar of Texas. She engages with others in a respectful and kind manner. Laura, after her tenure as chair of the board, developed a program for succession planning, especially for the benefit of solos and small firms. She is a graduate of Texas A&M University and my alma mater, the University of Houston Law Center. Laura is also my friend. When I arrived at the annual meeting last year as a first-year director, she and her husband, Bill Ogden, showed me kindness, grace, humor, and respect. I left the annual meeting feeling a part of the board instead of just a first-year director. Laura continues to be a big part of my life in teaching me about service to the bar and its members. She will make an outstanding president of the State Bar of Texas. Thank you. I yield the floor.
All right, Ms. Laura Gibson, are you on our call?
Yes, sir, I am.
All right, you have the floor, Laura.
Thank you so much, Chair Ginn. Thank you, Diane, for those really generous words. I appreciate them very much. Good afternoon. For those of you I've not met, my name is Laura Gibson, and I'm honored to be a board-nominated candidate for president-elect of the State Bar of Texas. I've been practicing law in Houston for 36 years. I started my career at a mid-sized Texas-based firm as an associate and later partner. And in 1993, I founded a 4-person trial firm where I practiced for 24 years. I now work at the 6-lawyer Houston office of Denton's, where I head up the Texas Labor and Employment section. I didn't get involved in bar activities until we opened Ogden Gibson in 1993. I got involved because having my own small firm brought home the importance to me of connecting with other lawyers. I needed referral sources in order to maintain my trial docket. And I started on the committee level with the Houston Bar Association, first volunteering for the Minority Opportunities in the Legal Profession Committee. Later, I got involved in the Labor and Employment section, and I worked my way up to become chair of the section. When I was chair of the section, I recruited underrepresented plaintiffs' lawyers, many of whom were not even members of the HBA. I asked them to join the HBA, and I invited some of them to serve on the council. I told our council members it was important for all of us to be ambassadors. I encouraged them to treat our section lunches like it was an event they were hosting at their home. I asked them to get to know as many people as possible and to welcome them to our group. On the state bar level, after having an opportunity to speak at the Texas Minority Council program, I started to attend the TMCP every year. I got involved with the steering committee. And as an example of my efforts to make people always feel welcome, I suggested that we create a dine-around program. This was to connect lawyers who were attending the seminar on their own without other friends or lawyers at the conference that they knew. We created a dine-around event where the State Bar made dinner reservations at nearby restaurants. They put out sign-up sheets on a first-come, first-served basis, and the lawyers could dine with people they didn't know. The groups that went out to dinner came back from dinner together, and that caused everybody to feel comfortable in participating in the after party. I'm proud to say that the Dine Around program continues to introduce lawyers to one another. In addition to focusing on inclusion, I'm a pretty hard worker. I have been blessed to have a tremendous amount of energy, and more importantly, an amazing assistant who helps me accomplish more than I could do on my own. For that, I'm so appreciative of Leanne Del Angel, my longtime assistant. One of my favorite quotes is by Winston Churchill. "We make a living by what we get, but we make a life by what we give." I want to give my time and energy to making sure all of our lawyers have an equal opportunity to succeed. I've been working to promote diversity and equality of opportunity for almost as long as I've been a lawyer. After George Floyd was killed on May 25, when former police officer Derek Chauvin knelt on Mr. Floyd's neck for nearly 8 minutes, I was so outraged, as were so many others. That week, I formed the Liberty and Justice for All Task Force. Our task force is working to increase the number of people who are registered to vote in the November 4 election. After the election, we intend to turn our attention to implementing voter reforms in Texas, which are very much needed. If elected president-elect, I will focus on 3 main platforms. First, creating and supporting diverse small group lawyers for newly licensed lawyers, where the State Bar helps the lawyer peers get to know one another, share best practices, and become better connected with their legal community. Second, implementing a We Care campaign for lawyers for whom outward indications, such as their involvement with TLAP or the grievance system, indicate risks for suicide, depression, or substance abuse. And third, designating a grievance support attorney, modeled after the succession planning designation of custodian attorney, so that any Texas lawyer who fails to respond to a grievance can have a designated mentor intervene on his or her behalf to make sure they file a response. I'm a strong leader. I have a proven track record of accomplishments that create meaningful change. I will devote my time, my energy, my innovation, my judgment, and my diplomacy for the benefit of the bar, its members, and our public. I will be inclusive. I will never marginalize or demean anyone. I will run a strong and fair campaign. And if elected, I will do the work necessary to lead our bar to greater good. I thank you very much for your time and attention. I look forward to continue to serve our wonderful members and the public who put their trust in us. Thank you so much.
Thank you, Laura. And like I told Sarah, I know that you both are going to have incredible campaigns, and we're excited to watch you both. And we're in good hands here at the State Bar. Thank you for being here today. Randy, before we go back to you, we're going to go back into closed session very quickly. So if all of our directors will just sit tight, we'll get you in there, and we're going to go into closed session. Before we do that, let me read the statutory requirements. It is now 2:59 p.m. and the State Bar Board of Directors will now recess the open meeting and reconvene in closed session pursuant to Texas Government Code, Section 551.071, for the purposes of consulting with legal counsel to deliberate regarding the potential purchase of real property at 1415 Lavaca Street in Austin, Texas. So with that, we will go into closed session. Everyone sit tight. Thank you. All right, can y'all hear me okay?
Yes.
All right, good deal. It is 3:11 p.m. and we are back in session. Let me find my language here. No, we do not. All right, we are back in session at 3:11 p.m. The board took no action pursuant to the closed session in our discussion with 1415 Lavaca Street in Austin, Texas. Mr. Sorrells, it's your floor. We were in the middle of your report. The floor is yours, sir.
Yes, and this is the Nominations and Elections Subcommittee report. We're just going to talk about signatures, electronic signatures, which were mentioned earlier. As you all know, by March 1st, both the directors and any petition candidate for president-elect have to submit their signatures. In the past, we've required wet signatures, in-person signatures, and obviously during the pandemic, that does not make a lot of sense. In the past, you could send around a petition. People could print it, sign it, scan it, and send it back in. The state bar would accept that. But in this instance, based upon these circumstances and this election cycle only for the time being, we're proposing accepting an electronic signature. And by electronic signature, what I mean is something like an Adobe Acrobat signature, where if you have a candidate's petition form signed with a program that is clearly the signor's signature, as shown here by Chelsea, that would be acceptable to use during this particular election cycle only. So on behalf of the Nominations and Elections Subcommittee, I make a motion that electronic signatures on petitions for president-elect and director will be acceptable during the current election cycle, provided the electronic signatures are facsimiles of the signor's own signature.
I second.
Charlie, you're on mute. You're on mute, Charlie.
Coming from a committee, it doesn't require a second, Director Tolchin, but I appreciate your enthusiasm nonetheless. Is there any discussion? I see Director Fisher's hand is raised. Director Fisher, the floor is yours. Steve, you just did what I did. You're muted.
All right.
Director Fisher.
I think for this election, it's probably a wise idea. But if we look at the big picture, that we get such low voter turnout, and we can't just keep making excuses. We should have more active participation. Many people, including Randy, even Laura Gibson, mentioned that we need to lower those signature requirements, and we can do it in the rules where it says the bar can nominate 2 or more. And we could just put the qualification for more being someone who served on a committee and got 1,500 signatures. In general, the reason I don't like online signatures is because I think if someone's running for bar president, they need to go out and talk to people and listen to what they have to say. Standing at courthouses is just normally the best thing to do because you really hear what people feel about the bar. But for this election, it's okay. It's very hard to do. Steve Bolden made a mistake, I think, when he said, well, now you have to get 5,000 signatures. In reality, in any petition drive, you need a lot more than that because so many of them are going to be wiped out, illegal, mistakes, unreadable, whatever. I think I got 6,122 to get 5,500 valid ones. So it's a good idea for this year, but we really need to do some of the things that Randy and others and so many people ran against and make it more democratic and more open for somebody who wants to run. Not as low as Larry or some people say 500 signatures, because somebody can get that just on the day that they're angry at the bar and 500 will sign. But something like 1,500. And I hope the elections subcommittee does that in the future. And thanks for your work, Randy.
All right. Any other discussion? Hearing none, seeing none. All those in favor, please respond by saying aye.
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 All opposed, respond by saying nay. Hearing none, the motion passes unanimously. Is there anything more to report, President Sorrells?
Not from me, Charlie. Thank you so much for allowing us to present this.
You bet. Thank you, sir, and thank you, Jerry, for your work. Thank you both for your leadership on this committee. Next action item is item 15B. It's a policy manual subcommittee. Adam Schrammick. Director Schrammick, you have the floor.
Great, thanks so much. Before we have two action items to deal with today, but before we do, I just want to give everyone a very quick update on the other matters that have been referred to the policy subcommittee. We've had 2 meetings since our last quarterly meeting as a result of some of the special board meeting issues. As you may recall, we have 3 what I would call significant issues under consideration, which is a code of conduct for officers and directors, standards for impeachment and removal of those officers and directors, and policies relating to increasing candidate vetting. We've already started the research and analysis of those issues is well underway. I did want to give everyone an update that we have retained counsel to assist us on the code of conduct and removal issues. That's our general counsel, Ross Fisher, as well as working with the in-house legal department. And we've also already begun working on the candidate vetting issue. And because I want everyone to kind of have a big picture of what's going to be coming as soon as potentially next quarterly meeting. On the candidate vetting front, we are working on an objective, essentially an application / disclosure form that would allow both the board members as well as members of the bar in general to have objective information collected about the candidates that both of them have to fill out so that everyone can see the background information and understand who they're voting for, and they'll have appropriately worded disclosure questions. We're working on that. It's going to be a lot of work to get it right. We're going to be working with the nomination subcommittee as part of that process, but that will be coming either next meeting or certainly by the following. So with that context aside, that's what we've been spending most of our time and energy on. But there are 2 kind of what I call cleanup issues that we had raised before the special board meetings came up that I want to talk about next and focus on. And if you're looking at your board manual, let me see, I'm sorry, our board meeting agenda, let's see, page 703 of 964 are the 2 provisions we're going to be talking about, the 2 policies that we're going to be amending. I think there was a PowerPoint, is that right, Lowell, that was going to have these up so you don't have to turn to it? Perfect. All right, okay, so we have 3.0702 up first. So this is a bit of a cleanup with respect to a lot of the out of town and out of state really obligations of our officers and leaders. President, President-elect, Chair, they have a lot of obligations on behalf of the State Bar other than coming to these quarterly board meetings. A lot of times they're being asked to go to the American Bar meeting or, these national board and organizations. And when they do that, for the longest time, we've allowed them to bring a companion or spouse, and we've reimbursed the airfare for that person. So we do it for the president, president-elect, the chair, immediate past chair, public members, out-of-state liaisons, judicial liaisons, but we did not have the State Bar Executive Director in there. We've looked into this and we believe that it's appropriate for the Executive Director who has significant obligations, when we get out of COVID, of course, significant obligations that are travel related, that whether our current or future Executive Director wants to bring their spouse or companion on those, since they're gonna have to be out away so long, that they should be within the category of people who are eligible for that issue. Let's go ahead and jump to the second one if we could, Lowell. That way you have idea of both of them. The second one, again, it's also part of 3.07. Here we had a situation to where the policy manual currently says that for the upcoming fiscal year, the Executive Director has to prepare and submit the reimbursement policies and procedures to the Board Audit and Finance Committee. Well, we have a situation to where those procedures really haven't changed for several years, and yet we have this deadline, June 1 every year for that document to go to the committee. Well, they have it, it's part of the board materials. Why do we have that rule in place? And if you take a step back for a second, what the policy committee ultimately decided was, why are we tying it to this one point in time, every June 1 of every year, as opposed to saying, anytime you make a substantive change or revision to the reimbursement policies and procedures, you should get it to the Audit and Finance Committee within 30 days. In other words, if you submitted last year's by June 1 and you change something on July 1, you need to get it to the committee within 30 days, not you get to wait an entire year to say, oh, by the way, I changed that a month into the fiscal year. So this is providing, we think, a more common sense approach to if and when a reimbursement policy changes, make sure and get a copy to the Audit and Finance Committee as a part of their oversight obligations. So really what we're talking about this time around are just a couple of cleanups versus what will be coming soon, which are going to be much more substantive, and I have no doubt addressed by this board in great detail. So with that, I will start with the first one. If you want to back up a little, we'll go one behind. We'll start with the reimbursement for spouses or companions. And Mr. Chair, I move that we amend section 3.0702 to allow the State Bar Executive Director to be one of the persons eligible for reimbursement of spouse or companion airfare costs.
Coming from a committee, it needs no second.
Oh, never mind.
Is there any discussion? I see Director Fisher, you have your hand up. Yes, sir. Please unmute yourself.
I just have a question. The public directors and public members were included. What about the other directors, the regular, board? I mean, would they be allowed maybe even once a year to bring a spouse? Some of us don't live close to the meetings. I just want to know if there was any talk about that, Adam, or any discussion.
There was not any discussion at that point. This was an issue that apparently had come up before about the executive director not being, because I think typically on these other items, it's primarily out-of-state travel that the other officers are doing. And so that was kind of where the need was. So we did not address or discuss anything about whether or not we should add directors to that list.
Good enough.
Any other discussion? Hearing none, seeing none. We have a motion on the floor. All those in favor, please respond by saying aye.
Aye.
Aye. Aye.
Any opposed? Hearing none, the motion passes unanimously.
Great. So if we go to the second one, I next would like to make a motion to amend section 3.07.01 of the Policy and Procedure Manual to change the requirement such that the any changes to the reimbursement policies and procedures made by the executive director shall be submitted to the Board Audit and Finance Committee within 30 days of that change.
Coming from a committee, it does not require a second. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Aye.
All opposed, please say nay. Hearing none, the motion passes unanimously.
And that's all we have this time around, Mr. Chair. Thank you.
Thank you, Director Schrammick, for your work and for your committee's work on this. Item number 16 is my friend, Director Steve Naylor. Director Naylor, the floor is yours.
Thank you, Mr. Chair. We have I know everybody's late and it's late and everybody's tired, but this one's pretty long and a lot of people have been waiting for it. We have several action items. Our report today is especially important as it contains various disciplinary rule proposals and a recommendation for the board to consider approving a procedure for a rules vote or referendum. I know we don't like to use that word, to submit to the Supreme Court of Texas. The materials for our report were posted in Board Effect, and I hope everyone had a chance to review them. To give you a little background information, the DCAP committee is an acronym for Discipline Client Attorney Assistance Program. We are a board committee that works with the Chief Disciplinary Counsel and the Commission for Lawyer Discipline to monitor the policies and procedures of the disciplinary system. We also review proposed amendments to the Texas Disciplinary Rules and Disciplinary Rules of Procedure as submitted by the Committee on Disciplinary Rules and Referenda, or CDRR. As a result of that, we make recommendations to the board on these proposed amendments. There are a number of steps in this process to amend disciplinary rules, and I'm going to summarize them briefly for everyone's memory. The first step is that the CDRR studies the disciplinary rules and disciplinary rules of procedure and makes recommendations to the board. The CDRR conducts public hearings, and they go to great efforts to obtain public feedback on their work. Among other things, they publish their proposals in the Bar Journal, the Texas Register, on their website, and they email membership about their progress. Once the proposals reach the board, they are studied by our committee, as mentioned earlier. We will recommend to the board whether they should be approved, disapproved, sent back to the CDR. If the proposals are approved, we submit a petition to the Supreme Court asking them to order a rules vote. The Supreme Court will issue an order for a rules vote, which will identify the rules that are included in the vote, the format of the ballot, and a schedule for when that ballot occurs. We then conduct a rules vote where eligible members of the bar have an opportunity to vote on the proposals. After the vote has been completed, the Supreme Court may approve, reject a rule in its entirety, or if it does not vote within 120 days, they are considered approved. That's the high-level overview. Over the last year and a half or so, the board has reviewed and approved several rule proposals submitted to the CDRR. In your packet, under the DCAP tab, is a document titled Summary of Proposed Rules. Let's pull that document up on our Zoom screen so we can all look at it, and I believe Chelsea is going to share that with us. Thank you. As you can see, there are 6 proposed amendments that have been approved by the board through this past June. These items are listed here along with a brief explanation of each proposal. We are not going to talk about these items today in detail because we've already done that and they've already been approved. But we wanted to show this to you to give you a big picture perspective. The last 2 items on the document will be considered by the board today. We also included a complete red line of all rule proposals in the board packet so that you can see the complete set of rules line by line. That leads me to the action item 16.2a. On the board agenda under DCAP, consider, discuss approval of proposed rule 1.05 C10, the Texas Disciplinary Rules of Professional Conduct, relating to confidentiality of information and clients contemplating suicide. The proposed rule only gives the lawyer permissive option of disclosing confidential information when the lawyer has a reasonable belief it is necessary to prevent the client from dying by suicide, thereby protecting the lawyer from professional discipline under such circumstances. A lawyer is not required to disclose confidential information under the proposed rule, nor is the lawyer required to make a medical determination. The current rules do not give a per se exception to reveal confidential information in these situations, so the new rule will provide clarity for lawyers. Mr. Chair, on behalf of the DCAP committee, I'd like to make a motion to approve proposed rule 1.05 C10 of the Texas Disciplinary Rules of Professional Conduct relating to confidentiality of information and clients contemplating suicide.
Coming from a committee, it does not require a second. Is there any discussion? Seeing no hands, hearing no comments, all those in favor, please respond by saying aye.
Aye.
Aye. Any opposed? Hearing none, the motion passes.
Thank you, Mr. Chair. The next item is number 16-2B under the DCAP agenda. Consider and discuss approval of proposed amendments to Rule 8.03 of the Texas Disciplinary Rules of Professional Conduct and Rules 1.06 and 9.01 of the Texas Rules of Disciplinary Procedure. The proposed amendments expressly extend self-reporting and reciprocal discipline provisions to cover discipline by a federal court or federal agency. Excuse me. The proposals also define discipline by a federal court or federal agency to mean a public reprimand, suspension, or disbarment, but they clarify that the term discipline does not include a letter of warning or admonishment or a similar advisory by a federal court or federal agency. Additionally, the proposed self-reporting and reciprocal discipline provisions are not applicable to mere procedural disqualifications in a particular case before a federal court or federal agency. On behalf of the DCAP committee, I'd like to make a motion to approve proposed amendments to Rule 8.03 of the Texas Disciplinary Rules of Professional Conduct and Rules 1.06 and 9.01 of the Texas Rules of Disciplinary Procedure relating to reporting professional misconduct and reciprocal discipline for federal court or federal agency discipline.
Coming from a committee, it does not require a second. I do see a hand, Director Lydia Mount, for discussion. Director Mount, the floor is yours. Lydia, make sure you're off mute.
I got it. Thank you. I had a question with regard to federal agency. There were some notes from members of the public that they were concerned about federal agency action. If anyone does a search for federal agencies in the United States of America, you will find that there are over 450. There's about 456 federal agencies. Is there any way to limit in the proposed changes which federal agencies we are referring to? Because it seems that there was some concern that a person could somehow be disciplined in their legal profession for something that happened that had absolutely no relation to their work as an attorney. And so I want to just make sure that we're clear with regard to what it is that needs to be self-reported, because the term federal agency is really, really broad, considering that we have 456 federal agencies in this country.
I will try to address that. There was a lot of discussion in our committee, and my committee members that are on, if they remember differently, we did discuss it, but there was no recommendation by any member to try to draft a limited number, because I guess we would have to go through the 456, did you say, and say 450 of them are included, 450 are excluded. There was no discussion about limiting agency. I think if it qualifies as a discipline, then it's, no matter what the agency is, if it qualifies under that definition, that we expanded the definition, tried to make it very clear on what discipline was, being disciplined, that it would fall under this rule. Ray, it was on, I'm hoping it was on. Ray, do you remember anything else, any other comment about this?
No, that's what I remember. Steve, and I think Brad Johnson is on as well, yes, the attorney for CDRR. And Brad, do you have any other explanation?
Thank you, Ray. Can you hear me okay?
Yes.
Yes, we can.
Okay. Thank you, Steve, and thank you, Chair. To answer that question, and just to clarify, I'm Brad Johnson. I'm the staff attorney to the Committee on Disciplinary Rules and Referenda. I don't believe that there was any discussion about naming each federal agency to which this would apply, but I would note that there is a definition of what constitutes professional misconduct in the disciplinary rules. So if it doesn't meet that definition, it wouldn't implicate this rule. So I think there was an example of like getting a ticket, maybe at a national, park or something that has nothing to do with the practice of law. That wouldn't be covered by the proposal.
I guess what I wanted to make sure is that if an individual, and I'm sorry, Mr. Chairman, I think I spoke out of turn. Okay. So I just want to make sure that if somebody were to look for an attorney on the State Bar website, and they saw that there was discipline reported, self-reported by an attorney, that would probably be alarming. And so how is there a distinction between self-reporting that a person got a citation from either the National Park Service or the Fish and Wildlife Service? How does a person who doesn't know, or a member of the public, somebody who's maybe not familiar with all of the intricacies in these rules, how do they distinguish that, well, this person, they got in trouble for fishing without a license, as opposed to this person got in trouble for something they did with regard to the representation of a client in state or federal court? Because if they have an obligation to self-report something like that maybe isn't very clearly stated out, but they report it because they fear that they're under an obligation to do so, how do we stop that from damaging a person professionally? I'm just, and I think my real concern here is that the term federal agency is so broad that somebody might feel they have to report, and then that's on their record with the state bar, and it really shouldn't be, because it has nothing to do with their ability to properly represent their clients or with their conduct in court.
I'll try to answer this before, and then Brad can correct me. But it's going to be very similar to your own self-reporting of what you understand about the Texas rules. If you are worried about that you may need to report something, you will probably need to reach out to someone in the bar and get clarification to see if it falls under something that you need to report. As far as a citizen saying, well, how can, I want to make sure, why weren't they reported? I mean, I'm pretty sure they run into this when they say, I know my neighbor filed a grievance against this lawyer for mishandling their divorce. And when I look online, I don't see it. Well, that's because it was found of no merit. But I believe the law, some of this burden will fall to the lawyer, that if they are not sure, to reach out and get clarification on whether they should report it. Brad, am I way off base here?
That's correct, Steve. And I would just add that there's really two components to this. The first is the reporting of the discipline, which is covered by the disciplinary rules of professional conduct. That doesn't trigger any kind of notification on the bar's website that an attorney's been disciplined and, in any jurisdiction. That's simply a report that, if you currently, the rule reads that if you're disciplined by the attorney regulatory agency of another jurisdiction, that you have to report that to the Chief Disciplinary Counsel's office within 30 days. But there's no automatic notation on the bar's website or anywhere else about that. Now, that could trigger the reciprocal discipline provisions that we're talking about if that conduct would constitute professional misconduct in Texas. But it sets the process in motion. There would still have to be an adjudication in Texas. And only at that point, once there was some kind of order here imposing reciprocal discipline, would there be anything posted publicly on the state bar's website?
Well, I guess my final question is there any way to be more specific with regard to federal agency?
Well, I don't believe so, because again, unless we sit down and go through every agency, but even then, what if that agency has the ability to issue some sort of professional misconduct finding? I think we're going to have to rely on the definition of professional misconduct and the actions that we have defined in here. But I'll wait and see if Brad or Ray or someone has a different opinion.
And Director Mount, after that, you're welcome to raise your hand again, but I'm going to work for some other folks to ask some questions after this, okay? You're welcome to get back in the queue, though. Brad, did you have any follow-up to that?
Yeah, the only thing I would add is that was the form that it's in is the way that the Committee on Disciplinary Rules and Referenda recommended it during the drafting stage. But again, and the report would be to the Chief Disciplinary Counsel's office, which generally everything's confidential dealing with the Chief Disciplinary Counsel's office as opposed to bar membership generally. But no, this is the version that the committee ultimately voted to recommend.
Director Tolchin, the floor is yours.
I'm just curious if this is retroactive or a going forward kind of thing.
It will be going forward, correct, Brad?
Brad, you're muted.
Correct. Okay, unmuted now. That's correct. I assume if this did pass a referendum vote and the Supreme Court issued an order adopting this or any other rule changes, it would notate an effective date. But that's right. It would be. I would foresee this only being going forward.
Director Harris, you've got the floor.
Just a quick question. Is there a penalty for failure to self-report?
Brad, that's probably for you.
So under the current disciplinary rules of professional conduct, there is a rule in place that says you do have to self-report discipline issued by the attorney regulatory agency of another jurisdiction. And that's in place now Currently it apply, the way it's worded, it would apply to other state bars. This would simply extend that to, federal courts and federal agencies. But yes, if someone did not report timely, then theoretically they could be subject to a grievance and discipline for failing to report.
Thank you.
Director Wilson, Kimberly Wilson, the floor is yours.
Thank you, Chairman. I think, and I don't know if this addresses Lydia's, Ms. Mount's concern, but just the definition of professional misconduct includes attorney conduct. So just to clarify and make sure that I understood, and I was brand new on the committee when we brought this forward, that the requirement for reporting is for professional misconduct, which is defined as attorney conduct. So not if you get a ticket fishing on a lake.
Brad,
Is that right,
correct?
Brad?
That's absolutely correct. It would have to meet the definition of professional misconduct in the Texas Rules of Disciplinary Procedure. If it was unrelated to the practice of law, then that would not be relevant to these rule changes.
And I think that, I don't know, Ms. Mount, if that addresses your concern. I'm sitting here looking at the definition of professional misconduct in our board information, which, 1,045 pages. So, and I think we kept saying that's defined, but it specifically defines it as attorney conduct. So to me, that helped me not be concerned about what federal agency might discipline, but that it would be disciplined for attorney conduct. So I hope that helps clarify.
Director Schrammick, you've got the floor.
Well, Director Wilson, I think, stole my thunder, but I agree that this is all in the context of professional misconduct. So you're acting in your capacity as an attorney representing a client. And I don't think we would want to line item the federal agencies, because an attorney can represent a client before any federal agency if they have an issue. This is really talking about what the attorney is doing when they're appearing in those federal agencies or before a federal court that this rule is getting at. And so I don't think we should line item or try to remove any. I think it's appropriately worded, and I think it makes a lot of sense. And it's just a self-reporting requirement so that the Texas officials can determine whether or not they think additional action should be taken based on the facts and circumstances. So it's not like we're impeding the prosecutorial discretion they have at any given time. They just want to make sure they know about it.
Director Dawson.
I call the question.
All right. All those in favor, please respond by saying aye.
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 Any opposed? All right, hearing none, the motion passes. Director Naylor, do you have anything else for us? Steve, you could be on mute, man. Just guessing.
All right, I'll move forward. It said that you had muted me, so I was waiting for y'all to unmute me. I apologize. Before we move on, yes, we do have several more things. I'd like to thank the CDRR for all their efforts over the past year and a half. They meet monthly, on a monthly basis, and have put in a lot of volunteer time and work on these proposals. They are very thoughtful and deliberate, and they've done an amazing job in getting this information to us. It's through their diligent efforts that we have a good package of rule proposals that we can move forward to the Supreme Court and the State Bar. Now, item number 16.2C, if your board materials, your board resolution for your consideration, I'll ask Chelsea if she can put that up on the board, on the share screen for us. Thank you. The resolution specifies all the rules that have been approved by the board since April of 2019. The rule proposals just approved by the board a few moments ago are included in this resolution. The resolution calls for the consideration of the following items: that the Board of Directors petition the Supreme Court of Texas pursuant to the Texas Government Code section to order a referendum on the proposed amendments by the eligible members of the State Bar. If the board approves this resolution today, the State Bar will submit a petition to the court on Monday for consideration of all these items. Please note that these are just recommendations that we are making to the court. They certainly can make changes to our recommendations pertaining to how we conduct the rules vote if they wish. Also, the resolution calls for approval of the proposed ballot form for a referendum as included in Appendix A, which will be distributed to the eligible members of the State Bar of Texas in paper ballot format and electric format. Chelsea, if you can put up Exhibit Appendix A, which is a sample form of the ballot. Thank you. The ballot is similar to formats that we have used in the past. It is clear and concise and allows the members to simply vote yes or no on each proposed amendment. It is not a one or none deal. Our committee had a long discussion on the method of voting for the election. Traditionally, the bar has used paper and electronic ballots for its elections. We considered using only an electronic ballot at this time, as we are generally moving that direction. However, we decided that for this particular vote, we strongly recommend using paper and electronic ballots to ensure that all lawyers have easy access to a ballot in order to promote a high turnout. The third action item on the resolution is the proposed schedule for the rules vote. After consulting with staff, we determined that a February start was optimal because it would give us several months of time to continue educating our members about the proposed rules. The resolution in your board packet has a start date of February 2nd and an end date of March 4th. On behalf of the DCAP committee, I'd like to make a motion to approve the following items as contained in the board resolution. One, that we petition the Supreme Court of Texas to order a referendum on the proposed amendments approved by the State Bar Board. The proposed ballot form for a referendum as included in Appendix A of this resolution, and that the ballots be distributed to eligible members of the State Bar of Texas in paper ballot format and electric form. That the referendum begin on February 2nd and end on March 4th, 2021.
Coming from the committee, there's no need for a second. Is there any discussion? Hearing none, seeing none, all in favor, please respond by saying aye.
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 Any opposed? Hearing none, the motion passes.
The last item on my report today is a discussion about communications plan for the bar moving forward to educate our members about these rules proposals. In your materials is a draft communications plan, which gives you an idea of some of the things we want to do to get the word out about these rule proposals. The bar will conduct CLE seminars, publish materials in the bar journal, and social media on our website, and we will send emails to our membership. Mr. Chair, that concludes my report, but I would ask the indulgence to thank all the members of the DCAP committee who have met on this many times. And as you were a former member of it, you know there was always some very lively discussion about some of these rules. But I would like to thank Diane St. Ives, Benny Agosto, Wendy Adele Humphrey, Mary L. Scott, Todd Smith, Kimberly Pack Wilson, Robert E. McKnight Jr., Luis Cardenas, Charlie Ginn, David Kent, Yolanda Cortez Matas, Emily Miller, Amy Peace, Adam Schrammick, and David Sergey. And that, I would also like to especially thank our State Bar staff who did so much work for us, and especially Ray Cantu. And that concludes my report, Mr. Chair.
Thank you, Director Naylor. And I will tell you that Steve and his committee, they have worked hard over the last 2 years. It's the second year that Director Naylor has been the chair of this, and it has been a long process and a tough process, and they have performed admirable. And we thank you, Steve, for your work and your committee for your work. With that, we'll go to item number 16, I guess B, under the Client Security Fund, Director Rob Crane. Director Crane, you've got the floor. Rob, you muted? Hey, Rob, you're muted.
Thank you, Mr. Chairman. The hardest working subcommittee in the State Bar of Texas met this Monday, September 21st, reviewed 13 applications for a total of $43,905.90. To date for this fiscal year, the committee has approved applications totaling over $142,000. Being the hardest working subcommittee of the State Bar of Texas, the members unanimously voted to add an additional meeting this year to not only consider more applications, but also to review and modify longstanding practices of the committee to potentially extend the health of the fund, as well as how to more efficiently handle the current significant inventory of applications And the hardest working subcommittee in the State Bar of Texas will report back at the January board meeting. That's my report, Mr. Chair.
Thank you for all of your hard work, both to you and your committee. This is one of my favorite committees that we have at the State Bar. I was on it for 2 years. I think it's a great committee. So thank you, Rob. Thank you, members of your committee, for working so hard. All right, let's go to the number 17 on our agenda, the Chair of the Audit and Finance Committee, Director Alistair Dawson. The floor is yours.
Thank you, Mr. Chair. Before I begin, I have a question for you, Mr. Chair.
Yes, sir.
When referring to you by your nickname, would you prefer TT or T squared?
Director Dawson, if you don't give a report, you're going to be muted.
All right. I will begin by saying that I bear good news. We are in good, strong financial shape. We have withstood the first 6 months of this pandemic, as I will go through. The materials for the Audit and Finance Committee are in section 17 of the meeting book, beginning way at the bottom, about page 915. So going to this stage, this shows you the total State Bar General Fund revenues for fiscal year 2019 to 2020. And as you can see, our revenues were just over $44 million and our expenses were $40.4 million. And then I gotta move my screen here. The ending fund balance was $20.39 million. Total revenues decreased by about $870,000, mostly due to the pandemic, but expenses also decreased by $460,000. The total board committed expenses were less than the prior year, resulting in an increase to the fund balance of approximately $2.6 million, bringing the total to $20 million. So we're going to break down the annual revenues and expenditures in the next 2 slides. So if we can go to the next slide, please. So this chart shows you the revenue trends of the general fund by department within the State Bar for the current fiscal year to date compared to the prior 2 years. You can see that the top 2 or 3 revenue generators are membership dues, Texas Bar CLE, and MCLE. I'm happy to report on the Texas Bar CLE, when the pandemic began, I was concerned as the chair of the audit committee of what that was going to do to our overall profitability and our overall budget. It turns out that the revenue for those Texas Bar CLE has gone down by 25% for the first 2 months of the fiscal year. However, as you'll see later, the expenses have gone down, so the net impact has not made a material difference to our budget. Turning to the next slide. So this slide shows you the expenditure trends of the general fund by division for fiscal year 2020 compared to the prior 2 years. The Public Protection Division shows the highest growth in expenditures due to changes made during the last sunset process. The board committee expenditures, the last column to the right, are varied from year to year since it is a spend of the prior year's excess funds from operations. This chart indicates that expenditure trends of the general fund remain stable over the last 3 years. And the actual expenditures, as I mentioned, of the Texas Bar CLE have gone down because they've been able to, the State Bar staff and the CLE staff have been able to work with hotels to either withdraw or modify hotel contracts and keep those expenses under control. Go to the next slide, please. So this slide shows a comparison of the operating results to the approved budget of the general fund for the prior fiscal year. As you can see, our revenues were increased by $975,000 and our expenditures were decreased or improved by $2.6 million, resulting in an overall net excess of $3.6 million. It was very, very good year last year in our financial performance. If you go to the next slide, please. So this is the general fund summary for the first 2 months of the fiscal year, our current fiscal year. Actual revenues were $7.6 million and total expenditures were $7.2 million. You can see that both of those vary significantly from what we had in the year prior. The board committed expenditures are $2.5 million, and that consists of $1.24 million for the technology fund President-elect Firth mentioned earlier. That had actually been in a prior budget, but had been deferred. And so there's some catch up there because it was taken out of a prior year's budget. There's a $515,000 contribution to the Access to Justice, $225,000 to the Sheeran and Crowley Memorial Trust that we heard about earlier, $333,000 for the Client Security Fund, and $200,000 for Law Practice Management and Texas Bar Books. In comparing this fiscal year to last fiscal year, you'll see that revenues are down by 1.6 million, but expenditures are also down by 1.3 million. You can go to the next slide, please. So this shows the general actual to budgeted financial reserves for the general fund. And you'll see that the actual net excess for the first 2 months of the current year was 332,000. And then you'll see that there's a budgeted net deficit of 1.16. And the reason that budgeted net deficit was in there is because we were moving Texas Bar CLE expenses earlier in the fiscal year. So it's a timing issue, but the bottom line is that we're 1.4 or 1.5 million ahead of budget thus far in the financial year. So it's a long way of saying that I do not anticipate that we're going to have a revised budget as a result of the pandemic. And I think we can stay with our budget that we have. We are doing very well. State Bar staff, and particularly those in the finance department, Tracy Jarrett and her team, are doing a great job at adapting to the challenges that have risen as a result of this pandemic. Turning to the next slide, I want the financial audit. This year, we have a new auditor. Weaver is doing the State Bar's financial audit for the year 2019-2020. And it's a new firm. You all, those who have been on the board will remember that they did some internal audit work for us previously. We were very happy with them, and the State Bar staff is very happy with the work that they've been doing. Field work for the audit goes from August through September, so it's already underway. The audit report will be presented to the Audit and Finance Committee in our January meeting, and will be presented to this board for consideration at the January meeting as well. Next slide, please. The internal audit is being done by McConnell and Jones. The field work on that will begin in October and should be completed by December. The audit scope includes sections management controls and an audit of the Chief Disciplinary Counsel's management controls and the processes as they relate to compliance with rules and policies. The internal audit will be presented to the Audit and Finance Committee at the April board meeting and be presented to this board for its consideration also at the April board meeting. Now I want to talk about our investments. Each year in this meeting, a representative from the State Bar's investment manager, PFM Asset Management, makes a presentation to the board on our investments. Prior to making this investment or providing this investment presentation today is Barry Boyer, who serves as a director with PFM. Mr. Boyer has over 17 years of experience working with local governments. He's a graduate of A&M University, Commerce with a BBNA and MBA. We won't hold that, us Longhorns won't hold that against him. He does a good job. And these licenses are required before an individual is authorized to solicit orders for securities. Now I'll turn it over to Barry for the investment manager annual presentation to the State Bar of Texas. Barry, would you walk us through the investment presentation, please?
I'd be happy to. Thank you, Mr. Dawson, Mr. Chairman, members of the board. Thank you so much for the opportunity to be with you here today. What you have in your packet, I'd like to cover just a couple of things. You have your August 2020 investment reports, and then you also have a broker-dealer list that you're looking to approve as an action item in Section D. I'll speak briefly about both of those. The copies of the State Bar's August 2020 investment reports are included. The general fund is currently invested in U.S. Treasuries, federal agency securities, commercial paper, and FDIC-insured CDs, as well as AAA-rated money market mutual funds. Overall, the portfolio of approximately $45.3 million is very liquid and maintains a very high credit quality. For the period ending August 31st, it generated a quarterly return of 0.13%, which actually outperformed its benchmark, the 6-month Merrill Lynch Treasury Index of 0.06%. We continue to work closely with Finance Division staff to monitor opportunities within the portfolio to ensure safety, liquidity, and yield on behalf of the bar in that order. Moving forward, the investment horizon, as you know, the climate has changed a great deal since COVID has come about since March and April. We are in very low interest rate environment, which we were in for several years between 2009 and 2015. We do expect rates to continue to stay low for the next few years, possibly through 2023. That being said, there's still opportunities to invest in the fixed income market, and we will continue to seek those out for the State Bar. We work with the bar through a contract that is referred to as non-discretionary, meaning that we do not execute trades without the authorization of Finance Division staff. We operate under the investment policy of the State Bar, which is further governed by Texas Local Government Code 2256. We're very excited to continue working with the State Bar. I feel like we have a great relationship with the staff there, and we're looking forward to continue to work with you in the year ahead. That will conclude my remarks regarding the investment report. Moving ahead, I wanted to tell you briefly about our broker-dealer list that you have in the next item. You're required to review and approve that annually under the guidance of the Texas Local Government Texas Local Government Code 2256 of the Public Funds Act. But briefly regarding our broker-dealer list, as we maintain that approved broker-dealer list, we have established policies and procedures to evaluate and monitor the firm's creditworthiness and their ability to perform the duties necessary for efficient trade execution. Our Fixed Income Credit Committee assesses many important factors, including market presence, capitalization, company history, profitability management, product availability, trade execution, timeliness of information, quality of service and personnel, and special circumstances such as qualified minority women-owned business enterprise firms when we evaluate who gets on this list. These are the firms we execute trades for on behalf of the bar. As an independent investment advisor, we work with them on your behalf. We don't inventory securities ourselves. We work with these firms to deliver securities to your third-party safekeeping agent for your portfolio. But you are required to approve this list on an annual basis, so we present it for you today. With that, Mr. Dawson, I will pass it back to you.
Thank you, Barry. Mr. Chair, on behalf of the Audit and Finance Committee, I make a motion to accept the August 2020 State Bar Quarterly Investment Reports.
Coming from the committee, no second is required. Is there any discussion on this matter? Hearing none, seeing none, all those in favor, please say aye.
Aye.
Aye. Any opposed? All right, the motion passes.
Mr. Chair, according to the Public Funds Investment Act, the board must approve the State Bar's Public Funds Investment Act trainers on an annual basis. Included in your board packet is a write-up of the training offered by Texas State University. On behalf of the Audit and Finance Committee, I make a motion to approve this entity to provide Public Funds Investment Act training for State Bar staff.
Coming from a committee, no second is required. Any discussion? Hearing none, seeing none, all those in favor say aye.
Aye. Aye.
Any nays? Hearing none, the motion passes.
Mr. Chair, the Public Funds Investment Act requires that the board annually review and adopt a list of qualified brokers that are authorized to engage in investment transactions with the State Bar. As mentioned, a list of the qualified brokers is in the board packet. These brokers comply with Security and Exchange Commission requirements. On behalf of the Audit and Finance Committee, I make a motion to adopt the current PFM dealer broker list for investments, which is included in your board packet.
Coming from a committee, no second is required. Any discussion? Hearing none, seeing none, all those in favor, please say aye.
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 Any opposed? Hearing none, the motion passes.
And Mr. Chair, I think I have two more motions. The Public Funds Investment Act requires that the board adopt the State Bar's investment policy on an annual basis. A copy of the investment policy is in the board packet. This policy has no revisions from the policy that was approved by last year's board. On behalf of the Audit and Finance Committee, I make a motion to approve the adoption of the State Bar of Texas investment policy.
Coming from a committee, it requires no second. Any discussion? Hearing none, seeing none. All those in favor, please respond by saying aye.
Aye.
Any opposed? Motion passes.
And I believe what is my final motion was mentioned earlier. The Audit and Finance Committee and the Board Policy Subcommittee reviewed a proposed change to the Board Policy Manual regarding purchase orders. Board Policy Manual currently requires that all items costing $500 or greater must be purchased through a purchase order. This requirement causes a significant amount of State Bar resources to implement, resources that would be better committed to all that money elsewhere. As a result, the proposed change revises Board Policy Manual Section 3.06.08 to read as follows. The Executive Director shall periodically establish a purchase order threshold not to exceed $25,000 and shall publish the threshold amount in the State Bar Procurement Guide. A purchase order shall be issued for any item costing more than the threshold amount. And I will advise the board that the initial proposed threshold amount is $5,000. I will also advise the board that this language has been approved by the Policy Manual Subcommittee. And finally, I will advise the board that making this change doesn't change anything about the who has to sign off on any purchases. It doesn't change anything about who has to approve purchases. It's just taking away the ability to or the requirement to use purchase orders. So on behalf of the Audit and Finance Committee, I hereby make a motion to adopt the proposed changes to Section 3.0608 Purchase Order System of the Board of Policy Manual as presented in the board materials and as I have read here today.
Coming from a committee, it requires no second. There is a discussion hand raised. I see Director Forbes. Lucy, you have the floor. Lucy, unmute yourself.
Sorry, I have a question for Director Dawson, and he may have answered it, but wow, that's a big jump from 500 to 25,000. That just seems like a huge jump. Can you please explain?
So my understanding is that the $500 requirement has been around for, I don't want to give away, a State Bar staff member who said it's been around since as long as he or she has been there, and that he or she had been there for like 30 years. I don't want to say who it was. It's just antiquated, Lucy, and nobody uses purchase orders to buy $500 or $750. I would frankly need to ask Director Schrammick it was his committee that came up with the language. I think that the reasoning, and he can correct me if I'm wrong, is that so that they don't have to go back and change it in the future. This gives the executive director the authority to set it up to 25,000. But as I mentioned, the initial requirement, as I understand it, would be 5,000. But rather than have to revisit this issue over time, they've given the executive director that discretion. And Director Schrammick can correct me if I'm wrong.
Director Schrammick, do you have anything to add to that?
Sure. We looked at several different ways to do it. We at one point were saying we could put a kind of a cost of living increase on it, kind of as things go up. Ultimately, where we landed is several of us are on nonprofit boards that have significant budgets, and we kind of polled each other informally and found that $25,000 was kind of the limit that had been put on a lot of nonprofits, and that Trey was there when we were having this discussion, and he thinks $5,000 is the right amount. And so the idea is, we're going to give this broad range. You're never, you're not going to exceed 25,000 without board approval. But honestly, we don't think we're ever going to get there. Not in the near long term. Probably, not until we're way off this board. So it was to give the flexibility, to the executive director to make that decision, and he can do it based on, kind of the experience and needs.
The $5,000 provision, where is that? Hold on.
No, it's not in there.
Oh, I see it. Okay.
Yeah, I'm just.
It's a previous provision. I mean, it's a previous one. Okay.
Yeah.
Thank you.
All right, Director Harris, you have the floor.
And this goes to Lucy's question a little bit. I think one of the other discussions that we had was that it's consistent with other state agencies.
Director Calvillo, you have the floor.
Yes, this is addressing Lucy's concern. There are also other internal controls that act as yet another safety net. Typically, you have purchase orders as one component in the system of internal controls, and there are others that are in place. So your question is very well placed, but I think there's other controls as well.
Thank you so much. Thank you.
All right, there is a motion on the floor. All those in favor, please respond by saying aye.
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 Any opposed? Hearing none, the motion passes.
That concludes my presentation, Mr. Chair.
Alistair, you and your committee have worked extremely hard on this. This is tough work, and we appreciate the dedication that you've shown. Because we like to have long meetings, we are in danger of losing our broadcast again. So we're going to take a quick 5-minute break. We're going to get a new broadcast link. Directors need to stay put where they are, right? Don't touch anything. All right, August, don't touch your computer or your dial. All right, don't touch anything. If you're watching, great. We'll have a new link, and we will take a short restroom break as well. So it's 4:12 now. Why don't we call it 4:20 when we come back? 4:20. See y'all in 7 minutes.